Yes, please.
Pardon to make a mention.
Please.
Not that Admiralty matter. Pardon, my lord.
Yes.
The Admiralty matter, through a judicial order, my lord, had sent it to the administrative side. That order has not been uploaded, my lord. I was just praying, my lord, if that order can be uploaded.
No, order has been uploaded. Before leaving the file, actually, I also asked that whether it has been uploaded.
My lord.
By what time you uploaded?
No, my lord,
I'm sorry, by what time you checked it?
My lord, 20 minutes, half an hour back, my lord, by 10:30 it was not uploaded.
So,
deeply obliged.
Yes.
Deeply.
Because since it was sent, so I think yesterday evening itself it has been sent.
I'll just cross-check it again, my lord, but...
no, regarding uploading, that can be a technical glitch.
My lord, I'll just...
At times uploading at this end, with this...
At this end.
May not show that in the main server.
My lord, I completely... Pardon, my lord.
Or there is some maybe inadvertently, I mean...
My lord.
Before being uploaded, it has been... but I hope it is there in the PC here. Whatever the system they are working on, it will be uploaded.
Deeply obliged.
It is around, say, 5:30. 5:30 yesterday evening, I asked. They said... Yes, Mr. City?
Pardon, item 13, my lord.
1-3, sir.
1-3. I have taken consent from the opposite OFDC counsel, Mr. Pitnamar Jana, taken up after vacation.
Date karantu? 23/6, Mr. Yes.
Pardon to be mentioning, your lordships. One TRPC case has been adjourned to...
Gyanranjan Seth, more na janchi?
Yes, lordships. A TRPC case number 285 of 23.
Mark kurchuni Gyanranjan Seth, Pitambara Jana. Further response. Mr. Senior should mention first. Yes, Mr. Das. 25, sir. Yes. Yes. What a week after date karantu? Again? I'll pass the order when the matter reaches, but I have noted. Yes. Yes,
item 24.
No. She was mentioning. He was amidst the...
One case of TRPC.
So fresh matter you are mentioning?
No, your lordship.
It's after notice.
Yes, your lordship.
So give the memo. Give the memo. Any assigned matter, please give the memo. No answer, but no preference.
Okay.
Yes.
Item 24.
Yes,
I have
24.
taken consent from the other side. It will be taken up after vacation.
Consent, don't make me a party to the consent. When the matter reaches, are you sure I was present when you took the consent?
Yes, I have taken consent.
I was present.
No.
So when you are mentioning in a court before the judge that you have taken consent, the judge must know. Both of you knowing so well or me knowing personally also doesn't matter. You talk to Mr. Khan.
Yes, sir. I have taken consent from the Khan man. Today morning I have requested.
No, I don't ask the time, sir. It can't be in the absence of the other person that I will be in a predictive path knowing that what has happened. Please don't do that. कौन चाहूँगी मिस्टर भुया केबे
week after vacation matter.
Date करंतु again 24/6.
Pardon, my lord. Item
Mr. Bhuya, Mr. Khan.
Item 35, my lord.
35, sir.
I am for the opposite party. Will be taken up after vacation.
35 in absence of any after notice matter after.
Here, my
You are there.
The lordship, we have filed a IA for refund of 50% amount of.
So when do you want, Mr. Mohanty? ଆପଣ କେବେ ଚାହୁଁଛନ୍ତି?
Very short date. Any date, lordship.
Any date is not there in the calendar. I have been searching.
Any convenient.
My lord will file count.
Any convenient is also not there. My lord, please, any convenient. Those dates are not there. I'm watching. I can go by the High Court official calendar.
After vacation.
My personal calendar, I have some other.
After vacation.
After vacation, कहले.
25/6.
Pardon to make a mention, my lords.
Yes, please.
Item 26, my lords, I pray after vacation, my lords.
It is listed for the first time before this bench.
Yes, my lords, before this bench for the first time.
Why do you want after vacation? There is a stay.
Yes, my lord.
You are for the,
My lord, we are for the opposite party.
who is for the petitioner?
I am for the petitioner, my lord.
We've
You are,
taken
you are
consent.
so happy to be adjourned?
So inform my lord, other side, my lord. Kindly. Go ahead.
Adjourned. When do you want?
After vacation.
Date korantu. Mr. Jagjivan Pradhan.
My lord.
Mr.
Yes, Das. Shubhankar.
Shubhankar.
Yes.
Yes. 26 J. Pradhan, Shubhankar Das. Yes, next please.
Interim order is there, my lord.
Yes.
Grateful for it.
Yes, please. Yes.
Pardon to make a mention, my lord, item 21. As
Yes.
for the petitioner, my lord, my senior is out of station. Kindly take.
Your name, madam?
May I please, Lordship? I am for the opposite party, my lord, in item number 21.
Yes, yes. What
Let
is
the
your name?
matter-
Harapriya
Harapriya Sahoo.
Yes, my lord.
My lord, they have
On
taken
behalf
so many
of Consider-
adjournments.
He's objecting. He's objecting. So you either you agree or the matter will be taken up. Yes, what do you
No.
say?
No, agree, my lord. Not agree.
So when do you want? You a shorter date you want?
No, my lord, today, because this matter
You see, the
is
senior,
pending
when the
since
senior
nine-
is not there, I'll proceed ex parte.
they are taking, my lord,
So
plea on
have
this.
you not ever taken any accommodation in any court during your practice career?
My lord, they are
My lord, how the
Matter.
answer can be, my lord? Have you ever taken any accommodation in any court during your practice?
my lord.
Then, so you can say that your objection will be noted, but if you say that the matter will be taken up,
My
as
lord.
I told, so it will be expired. I'll proceed ex parte or what? Then they will file a petition for recalling the ex parte order. Be practical and pragmatic also. So when do you, ଆପଣ କେବେ shortest date କେବେ କୁହନ୍ତୁ? When they are objecting.
Next week, any date, my lord.
Any date nahi agya calendar re. Any date, my lord, please. Because I am very pleased to take it up today.
9th.
Yes, 9th. What do you say?
My lord.
ଆପଣ 9 ତାରିଖ ପାଇଁ ଠିକ ଅଛନ୍ତି ତ?
No, they-
ଟିକେ ଖୁସି ଲାଗୁନାହାନ୍ତି କହୁନାହାନ୍ତି ଆପଣ କୋଉଠି ଆପଣ ତ କହିବେନି
My lord,
you give a date, agree for a date.
9th ঠিক ଅଛି, my lord.
এটা your name sir? ଆପଣଙ୍କ ନାଁଟା କଣ?
ସୁଶାନ୍ତ କୁମାର ନାଥ.
ସୁଶାନ୍ତ ନାଥ.
Yes, my lord.
Objection.
Interim order to continue, my lord. Interim
Shall I make it peremptory? Why are you not reading brief yourself? Anyway, next.
interim order to continue.
Yes, noted.
Mention, my lord. Item
Wherever there is adjournment with interim order earlier, it will be continued. Don't worry.
Item
Yes.
number 32. I am for the petitioner. I will undertake to inform the other side counsel, my lord. Kindly, this matter may be taken up after 1 week.
32, Mr. Sahoo, you are for the petitioner.
Yes, my lord.
Your name is not there.
Yes, my lord. My name is.
You are A.K. Sahoo. Abhit Kumar.
No, my lord. A Sahoo only.
A. Sahoo. Other side?
They have entered their appearance. I will inform him.
No, not in future, sir. You can't
Okay.
preempt the other side in after notice matter as far as adjournment is concerned. So I'm noting it. When do you want?
15th May. my lord.
If they object, it will not be adjourned. Or any other date will be
Shorter
given.
day maybe.
No adverse order. So, but be ready for their mention also. So if you are not there in the court, you inform any of your learned colleagues. Yes. Next.
I may be pardoned to make a mention, my lords.
Yes.
Item number 38 and 39, my lords.
Yes.
On behalf of Mr. M.K. Mahapatra, I pray for after vacation.
Your name, sir?
Suman Sahu.
State is the appellant here. So, yes, Mr. City. After vacation, he wants. କରନ୍ତୁ ଆଜ୍ଞା କରନ୍ତୁ 2 7 38 ଆଉ 29
Yes.
sorry 39
Yes, ma'am.
yes
Pardon to
next
make a mention, my lord. Item number 30, my lord. I pray for on behalf of
38 sir
30.
On
On behalf of Mr. My lord, I pray for 2 weeks time for filing of rejoinder, my lord.
Your name, sir?
Mithu Kumar Biswal, my lord.
AK,
MK Biswal,
MK.
my lord.
When do you want, sir? Time?
2 weeks time, my lord.
2 weeks per date korantu.
My lord, interim order is there, my lord.
Have you informed the senior Mr.
Yes, my
Patnaik?
lord. Yes, my lord.
They have agreed for before vacation. I think he had some other work. 23/6 कहले. Interim order to continue.
Obliged, my lord.
You are seeking time to file rejoinder.
My lord.
Reply to rejoinder or what?
Reply to counter, my lord. Filing of rejoinder.
No, rejoinder, they... Achha, you want to file rejoinder?
Yes, my lord.
Yes.
Obliged.
Supplemental list, upload him. Okay? Achha. Time नथला जदि ठीक अछि ହେଇଯିବ. Mr. Mahanti, Mr. Mahanti. No, actually we had a very short window of time. So I must tell you that also. Hardly after I left my table, there was hardly about 15 minutes. All had to leave for some common, so that is how. So now I confirm that it has not been uploaded. It will be.
Well, deeply obliged.
It will.
Deeply obliged.
Yes. Yes, next, Mr. Rathod.
Hey, please, my lords. With my lord's kind permission, I'm through BCM intervener in this matter, my lord. May be permitted to place the matter.
Your intervention has been allowed, sir.
No, my lord.
When did you file intervention? It's a 2011 matter?
Yes, my lord. Because the due to in view of certain development in the meanwhile, I have been constrained to file this application. Because in way back in 2011, I was appointed as the cashier cum accountant, and in view of non-regularization of my service, I approached this Hon'Ble Court by writ application number 7534 of 2025. Which
Mr. Tripathi, kindly just, I hope you are listening to me. Since you are in VC, I'm sure you are listening to me.
My lord.
So you are seeking any relief in your intervention, or you want
Yes,
to support?
my lord. No, my lord.
No relief can be sought for in their intervention application.
No, my lord, my predicament is
Check the
that
provision. There is no such provision in CPC nor in the High Court rules. If you want a relief in your prayer is a relief, it has to be a writ petition. Maybe analogously hard, that's another thing.
My lord, in view of certain consequential development.
Sir, you have told that. After you said that there is a consequence, there is some development, you are constrained to file the So I remember.
Yes, my lord.
It is almost, I can replay it. But
Yes.
my question is very specific. If you are seeking any relief, as you cannot join as a intern and seek a relief, because dominus lightus that principle. So whoever is proceeding, he will know how to conduct.
I'm not seeking any relief in this matter. Only
So then for intervention after 14 years is not important. You can remain present and watch the proceeding.
My lord, may be permitted to place one single point, my lord. For my lord's kind.
Sir, you place more than one, but in your petition. Please, that's the short point. In fact, you have got it. In the intervention petition, if I start hearing, then the problem is that the petitioner is the dominus lightus, he wants to prosecute. The opposite party is the answering party. They will answer. And the scope of intervention in any petition. Almost the CPC principle.
No, my lord. In view of annexure B, my lord.
No, what no, my lords? The CPC not applicable, principle not applicable, or what you are saying, no, my lord?
Yes, my lord. CPC is certainly applicable.
So those principles, so in intervention, I can't entertain a petition seeking relief. Either you support the petitioner, fair enough, you no need, or you oppose the petition as the opposite party.
I oppose.
Sorry,
but I hope Mr. Tripathi will be supporting the petitioner.
No, he's not saying then. So
he is not saying, but he is an employee under the management.
Yes.
Management is the petitioner challenging the registrar's order.
But he says that he was appointed as a cashier or something accountant.
Appointed by the
So
management.
if he is saying that it's a he has something to and he said regularization.
No, I have already been
cashier cannot be in a petition by the.
No, my lord. Regularization.
So my response to that only. In fact, what he said actually.
Your lordship is correct. But Mr. Tripathi should serve me a copy, whatever he has
I have
filed.
already solved now.
And make a substantive petition if you are seeking regularization.
I don't take a
No,
copy.
no, my lord. Annexure A, as per Annexure A, that is my lord's order dated 17/3/2025, direction has been given to the petitioner for regularization of my service.
Annex, how the order can be annexed, sir? When you are referring to annexer, it must be a past order.
It is a.
How can it be annexer? How do you say that annexer is the order is the annexer? It is an order sheet. You refer to order number and date.
Order number, my lord. Order number 1 dated 17/3/2025, my lord. That is my lord's order.
Annexer to intervention. To annexer to the intervention, perhaps.
Another case, direction.
Order number 1.
1 dated 17/3/2025. Page 6.
17/3/25 is, sir, is order number 5. Order number 5.
No, my lord, my application.
Application
application, sir, nothing turns on that, sir. By filing so many applications, nothing turns on that. You have to, I am thinking when you are mentioning annexer, so this order, it is order in the read petition. There is no such order, annexure 1. So, sir, there may be a direction for serving copy because it is a well established practice.
I have already served.
So you serve an extra copy on the learned instructing counsel. Yes, coming back to you.
Serve a copy with annexes.
Yes.
It may help me also.
Yes. No counter has been filed.
No, has not.
Still, the cause of action is there after.
In fact, these people are appointed as back as 2011.
Yes.
The register has nullified the selection process by the impugned order annexure 1 here, saying that the selection.
Is there any stay order? Any interim order?
There is an interim
order. To the effect?
That the services of the it is protected. They will not. No coercive
services are protected.
No coercive action, something like that is there. So they are all employees working under me. I am the management. I appointed them with that sanction of the register. Now the selection process was followed. Advertisement was published. People applied. Thereafter, on the basis of allegation of one of the committee member, the selection subcommittee member, his brother applied to be appointed. Since he could not get appointed, he raised allegations after allegations. The inquiry was conducted. Matter also has travelled to this honorable.
No, I mean the case could have been that the allegations would have been there, but since he blew up the lead because his brother could not get through.
Yes.
So the same thing. The argument is very dicey.
Either way,
very dangerous argument actually.
Right, my lord. Either way, allegation could have been there. Lordship is correct, my lord.
So allegations they surfaced only when one of the members.
I can't wriggle out of the allegation.
That's the problem.
I can't wriggle out of the allegation.
Because his grievance is that the discrimination.
But then only
everybody's relations and candidates got appointment. My candidate did not get appointment.
So the process is wrong.
This is reverse discrimination.
Process is wrong. Anyway, these people have been appointed since 2011. They are working for the bank. Now today, your lordship will see the register has passed an order without giving these people an opportunity of hearing.
He need not.
Because these people are already appointed. This order will apply.
The problem is that if the selection process goes,
everything will go.
Everything goes, and because they are the beneficiary of the selection process.
Yes.
At best.
They should have been given one chance.
No, Mr. Ratha, you are right in a sense, but the other part kindly consider. How can they justify the selection process? Only the persons involved in the selection process who are conducting the examination, they can.
There are some one or two judgments.
Opportunity in case of
affected
opportunity in case of malpractice.
No.
And that medical college, when the boys entered the ladies' hostel, so at night, opportunity of hearing. So that is Supreme Court decision. That is what medical college.
No, that ladies' hostel matter.
Yes.
The opportunity of natural justice is not a cure for everything, nor a
no, it's not unruly hearse. The same Supreme Court has said, the honorable judge has said that it's not an unruly hearse. If you unleash the unruly hearse, then this kind of situation will arise that when you see the selectee, now the question is assuming that you give them an opportunity. They certify that yes, the selection process is the best process adopted. One of the selectees, can it be? Could anything turn out of that?
Any view of the matter before hanging them, they will lose.
No, it is not a disciplinary procedure.
Sir, 2011 ru 2025.
They are not being hanged. They are beneficiaries of there are so many decisions as far as mass malpractice or selection process being vitiated. There are so many decisions.
All these people are continuing for 14 years. So they are also asking for
They
regulation.
took the risk actually.
Beg pardon?
Unless Mr. Tripathi, client, a particular candidate is targeted, I mean, not targeted, a particular candidate is removed, then there can be.
It's not a question of removal.
And it is for the selection committee to justify the selection process.
Obviously. Committee is before my lords. The committee of management is before my lords.
So individual person, how he will be asked? It becomes an empty formality.
But I'll address my lords.
Suppose now let us assume we give them an opportunity now. We let them put forth their answer.
Your lordship can call them up to put forth their answer. That is one part. That is one part. There are other parts also. Your lordship sees the registrar, while passing the order, has no jurisdiction to pass this order.
That is one thing.
That is the point.
That is the best point that you can take.
Yes.
Now, may I pray one thing?
Please.
The Annexure 1, this order has been passed on the basis of the direction given by this Honorable Court. That writ application is WPC 5051 by 2011. That order, that writ application may be taken up together along with that.
And that writ application was disposed of without hearing anyone. 50?
That 5051 of 2011, order dated 7/3/2011.
Order copy I have.
That writ application may be taken up along with the disposed of matter, but may be taken up. So that what was
Mr. Profulla Ratha, Senior Counsel, is Mr. Behera, A. Behera for the petitioner. Mr. Sanjeev Swai, AGA for the opposite party. All the opposite parties. Mr. Sakti Datta Tripathi, petitioner for the petitioner in the intervention application. It is submitted by the learned senior counsel that the petitioners challenge the cancellation of the selection process by the opposite selection process undertaken for selection of
different posts. Different posts.
Advertisement?
Hello?
Advertisement for selection?
But that's there.
Annexure 8?
That is page 30. Page 30.
For the advertisement, as annexed, copies of which, an advertisement, copies of which have been to the writ petition marked as Annexure 11 series. Of several dates and several newspapers. Sentence complete kale hela kon likhile padhilo. The petitioner management, petitioner president karibe, the petitioner, president of the Berhampur Cooperative Societies Bank challenges cancellation by the OP number 2, Registrar Cooperative Society of the selection process. The sentence complete kale. It is submitted that before cancellation of the selection process, no opportunity was given to the affected parties.
And also issue of jurisdiction and
it is submitted that the OP number so and so, G cancel kale, OP number 2 bade. OP number 2 lacks jurisdiction for cancelling the selection.
Right.
The learned AGA, referring to the order of cancellation annexed to the writ petition, submits that the said order was pursuant to the order dated 07.03.2011 in WPC number 5051 of 2011, directing the opposite party number 2 to take a decision on the report of DRCS, Deputy Registrar Cooperative Societies Marketing, within a week from the date of communication of the order relating to irregular recruitment made by the Berhampur Cooperative Urban Bank Limited. Stuff. On being asked that on being asked that how the selected persons can answer the allegation of irregular recruitment done by the bank authority oblique management. The learned senior counsel submits that he prima facie the RCS OP number 2 doesn't have jurisdiction to cancel the selection process. According to you, who could have?
In fact, it would be the committee of management which has taken up the cancellation selection process. The whole power is
Who could have cancelled then?
selection process would not have been by anyone. The statute do not provide that.
It is submitted that statute doesn't provide such power for the RCS to exercise. Stop.
My lord, my small intervention, my lord. My lord, it is rather
in view of the above, the records of WPC number 5051 of 2011 dated 7/3/2011 shall be called for and tagged for reference in this matter. The other significant aspect of the matter is that by interim order dated 25/4/2011 passed by the division bench, the selected candidates are stated to be continuing till date. The interim order dated 25/4/2011 in Miss Case number 6134/2011 is reproduced herein. Para. The Triparty Learned Counsel for the intervener submits that he seeks regularization.
my lord, I will submit the letter, my lord.
He seeks that he is one of the candidates who was selected as
He should have filed
As the accountant cum cashier, my lord.
accountant cum cashier by the selection process which has been struck down or which has been set aside by the RCS OP number 2.
No, my lord, that has not
Cancelled.
No, my lord, that has not been set aside. Not been cancelled, my lord.
Then why you read Kalidasa before filing this Kalidasa's life story?
No, my lord, because
Then why you are entering into this? I thought that you are one of the tainted candidates.
no, my lord, pursuant to my lord's order,
Annexure A.
my lord, pursuant to order dated 17/3/2025, I have been served communication.
No, don't go to 17/3/25. There is no such order 17/3/25.
I have been served communication of a letter
Kindly
dated.
see page 18. Page 18.
18.
Your Lordship will find the order passed by the register. This I am inclined to hold that process of selection suffers from several infirmities and therefore the said selection is not
No,
sustainable.
did you hear Mr. Tripathi or his voice? He says that he is not one of the candidates selected.
He is.
Yes, I have been selected, my
What
lord.
he
I
says,
have been selected.
Annexure A to the affidavit he has filed for intervention.
I 2025.
No, WPC 7534 of 2025.
Correct.
Yes, in that case, order has been passed to consider his case for regularization.
Yes.
Where you have found that?
That is Annexure A to the intervention application.
Intervention 6316.
Yes, that is IA number 6316.
Yes, that I was referring to.
Yes, page 6. You are referring to page 6. That is Annexure A. You got it.
So that writ petition is disposed of for consideration of representation.
This pendency of this case is creating hindrance for consideration.
Yes,
It will.
Therefore, he wants to.
It is pending since 2011.
Yes.
And Mr. Tripathi, you look at Annexure A.
Yes, Annexure B is
petition?
also important. Annexure B is also important.
Sir, so many things are important. You are on top of your brief, but let us consider the relevant aspect.
Yes, my lord.
In Annexure A, where you brought to the notice up to the coordinate bench of pendency of this petition.
I have not.
Then gone.
That is the
Because I have no knowledge that this petition is pending. Only pursuant to
Ignorantia juris non excusat.
no, my lord, pursuant to
Not knowing the pending proceedings in High Court or Supreme Court or any lower court is not a ground to come to court and say that.
My lord, only one humble submission,
The
my lord.
problem you do not bring to the notice of the court.
No, my lord. I have no knowledge, my lord.
Mr. Tripathi, your writ petition itself is misconceived on the first occasion.
No, my lord, may I have a glance to page 9, my lord, and to my application. That is the letter.
Now, can you, Mr. Tripathi, now can you deny the order passed in this 2011 writ petition?
I have no knowledge, my lord, because.
So fair enough. Sir, you plead ignorance.
My lord, in view of
Mr. Tripathi, ignorance is not to be argued. By you telling me I completely believe. Can I record that?
My lord, may kindly hear my movement, my lord.
Sir, you are being heard. Why you are pretending that you are not being heard?
My lord, only I am referring to Annexure B, my lord, for a movement, my lord, at page 9.
Mr. Tripathi, when you yourself are saying that you are not aware, it has to be recorded.
Yes.
I don't have a choice of not recording your statement.
Yes, my lord,
it is submitted by the learned counsel, Mr. Tripathi, for the appearing for the intervener, Mr. Satya Saurabha Maharana, that he is not aware of any of the earlier orders. The intending intervener is not aware of any of the earlier orders, such as order dated 7/3/2011 in WPC number 5051 of 2011, directing the RCS Odisha to take a decision on the report of the DRCS within a week relating to irregular recruitment made by the Berhampur Cooperative Urban Bank. He is also not aware of the pendency of this writ petition.
My lord, only
he was not aware of the pendency of this petition WPC 10004 of 2011.
Only on communication of
IA likhibe 6316 of 2025.
only one submission, my lord. Only one.
Order ta apno jeto dakuchonti apno submission re interrupt karantuni. If anything wrong is dictated, then you come back. Because I am not reproducing your dictation. Please appreciate that.
Sorry, ma'am.
When two people start dictating, is it possible to complete anything?
Sorry, ma'am.
Actual errors or any error, you are saying that please wait the whole process to be completed.
Sorry, ma'am.
You can't predicate that I will complete errors and mistakes.
No, ma'am.
And in also that's the problem. There is some time lag also.
Lord, I beg humble apology, my lord.
No, you need not. You have done nothing to apologize. This way, if you continue, then I have to apologize that everyone is apologizing.
No, my lord.
It's a competing apologies flowing from each other.
No, my lord. Sorry, my lord.
It's a fact. I'm stating that I'm dictating something. If you find anything wrong, please, but don't interrupt the process.
My lord.
It takes a lot of wastage of time.
Sorry.
And you see, this is a leftover hearing matter, so we have to go ahead. Paul likh le? Yeah. Mr. Tripathi refers to the order dated 17/3/2025, passed in WPC number 7534 of 2025, wherein in the writ petition filed at the instance of the intending intervener, the writ petition, the following order was passed disposing of the writ petition. Para 7 ta quote karibe, page 8 re achi, IA re. on being asked whether the petitioner brought to the notice of the coordinate bench when the writ petition 7534 of 2025 was taken up and order dated 7/3/2025 was passed.
17/3.
The earlier orders passed by different benches, including division bench. The direction to the RCS to take a decision on the report of the DRCS. It is submitted that the petitioner was not aware of such directions passed earlier directions by the court, for which nothing was mentioned in the writ petition 7534 of 2025, nor any order was brought to the notice of the coordinate bench. Yes, it will be adjourned or what?
My lord, only one humble submission, my lord.
Yes, yes.
My lord, next page, annexure B may kindly be seen for a moment. That is letter dated 9/4/2025 of the petitioner, my lord.
Yes, yes.
On communication of this letter only, I came to know that this writ petition is pending.
Sir, I don't want to know the reasons of how you came to know. You are in fact, I don't know. You are not following what I am saying. The question is very simple. You see, that shows how you are. Look at then. I will most humbly request you to look at for a moment page 6, annexure A.
Yes, madam.
Mark the order date.
17/3/2025.
25. Look at the order for a moment. What you have annexed at annexure B, which I looked at for a moment.
Yes, madam.
What is the date?
9/4/2025.
How is it relevant?
My lord, on communication of this.
So 17/3/2025. You saying that 19/4 order 9/4 is relevant.
No, my lord, on communication.
So what I have dictated that 17/3 your submission is that you are not aware.
Yes, madam.
So this 9/4/25 is self-serving. Whether you became aware by 9/4/2025, you did not read 9/4/2025 is makes no sense.
Yes, madam.
And don't ask the court to record that.
No.
I cannot record that. He came to know only on 9/4/2025. That is how he could not say anything.
Madam.
You have obtained an order from the coordinate bench. So there are for the firm and so if you are not aware, let you not be aware. I mean, ignorance is bliss, no problem. But the problem is that whether the bliss leads to anywhere, that's the problem, or the other issue. Ignorance of a court's order in division bench, series of orders, filing of writ petition, nothing you are aware. So that I have recorded. Yes. No further order is passed in the intervention application at present at the instance of the intending intervener, petitioner, staff. The learned counsel, Mr. Tripathi, prays for adjournment. Yes, when it can be listed, Mr. Ratha?
Sometime after vacation, my lord.
ଆପଣ ଉପରଟାରେ ଡେଟ୍ ଦେଇଛନ୍ତି ରିଟ୍ରେ ଦେଇଛନ୍ତି ସେଟା ଲେଖନ୍ତୁ କୋର୍ଟ ଲେଖିଲେ ସେଠି ଇନସର୍ଟ କରନ୍ତୁ yes Mr. Swine after vacation
Yes.
on consent list on 1/7/2025 ତାପରେ ଲେଖିବେ ଆପଣ ଇନଷ୍ଟ୍ରକ୍ସନ ନେବେ କାଉଣ୍ଟର ଫାଇଲ କରିବେ
Yes, we'll file a counter.
the learned AGS 6 for submits that he shall file counter though the matter is pending since 2011. The counter could not be filed. It is submitted by the counter could not be filed, and he may be accommodated further to file counter. How much time?
By that time.
By that counter shall be accepted by the next state upon serving copy thereof on the learned instructing counsel, Mr. Behra. लिस्ट ऑन एक साथ कर देबे तळे जोटा लिखिले आईए रे जोटा आपनकर इंटरवेंशन पई सेटा भी लिस्ट ऑन एक साथ
So may indicate along with WPC 505.
that order is passed. That order has passed in the writ petition. Because I think all these writ petitions now have to be taken up.
My lords.
Mr. Tripaঠি's client is in bliss. He doesn't know anything.
That cannot be modified.
Are you aware that you were selected by that selection process?
My lord, as per the selection, I was appointed by virtue of selection.
Now the things have little bit improved because you said that you were not selected by that tented selection process. I was asking Mr. Ratha.
No, my lord.
In fact, Mr. Ratha clarified that no, he is the person who has been selected.
My lord, my respected senior is correct.
No, it's fine.
Item 2.
Your Lordship, I am appearing on behalf of my senior, Mr. Chan.
What is the last order?
Your Lordship, this is the TRPC application which is filed of CP case number.
Kindly look at para 2 of the order dated 23/4/25. Mr. Samantra and you are Miss
S. Subhadarsini.
S. Subhadarsini.
Yes.
Miss S. Subhadarsini. On behalf of the petitioner kar debe Mr. J. Samantra for the opposite party. You have copy of that order?
No.
Dated 23/4/25.
Please, sir, copy done.
Just a digression. Mr. Swain, the first order was by the division bench, I think.
First order, that is not with me.
Because the second, this order is by division bench. So then the single bench assignment was not there.
Long back, yes. Only for the purpose of reference we have to.
No, I understand.
Yes.
But that is binding on all the courts,
Yes,
single
that is
benches.
fine. That is what my submission, that is
Yes,
submission.
yes.
Once direction is that, you have to proceed with the matter on the basis of the inquiry report.
Yes.
You have no other option to.
It has to be challenged.
Yes.
Or that in SLP, obviously division bench, one has to file SLP.
That is my submission. That is not my submission.
Or maybe it has to be assigned to a division bench. In some cases, recently, as you have marked while I was sitting in division, some single benches, since interim order was passed by the division bench, single benches where judge matters were listed before, so that there is no problem for the petitioner.
Yes.
Any instruction or you want adjournment? Go in these matters with a mindset of reconciliation. Please proceed.
What happened, my lord? That is a 125 petition is pending before the.
No, kindly read, sir.
Yes, my lord.
Kindly read the para 1. Just read out the order 23/4 order. In that.
Beg your pardon for the indulgence, Lordship. As per the instruction, both the cases are. I have no objection to transport to the Learned Family Court, the Lordship. As per previous order, Lordship 23/4/2025. Para 2, Lordship. May kindly have a glance, Lordship.
The petition is for transfer of by the wife from Begunia to Khordha to Begunia.
No, Bhubaneswar to Khordha.
Bhubaneswar to Khordha. So the husband has filed a petition for?
Husband is filed a petition, divorce petition, my lord.
Where?
Bhubaneswar. Yes, my lord. Then the wife is filed a petition before the family court, my lord. That is a 125.
Where?
Bhubaneswar.
She agrees for now to go to Khordha.
What happened, my lord? In this case, my lord, that is a 125 case is not stay, my lord. That is continue, my lord.
Sir, that's relevant while transferring a matter.
Evidence start he jai.
Could be. 125 evidence कौन नहीं आ जाए 302 evidence The only one question you will ask on the witness in doc, are you married? He will say yes or no. If he says yes, no cross-examination, no further proceeding. 125 CRPC re kon evidence nahi habo.
That is true, my
The husband is not disputing. Yes, Mr. Samantara.
difficulties there with the
No,
lawyer will be changed. It
no
will change
difficulty.
both the sides.
So no difficulty. Is the husband disputing? Answer, please answer the court's query.
I have intimated to that.
How can you intimate? If the husband is disputing, how he could have filed the CP for divorce? So once it is on record, no evidence is also necessary. If it is pleaded that a 130.13.1 petition is pending in so and so court, filed by the husband, so he doesn't deny the relationship. 125
Yes,
can be avoided only by, and now she agrees for so let both the matters go to Khordha tomorrow. Upon jo question instruction but don't proceed this way. The evidence has started, the matter has progressed substantially at Bhubaneswar. What is the status of CP case? At Bhubaneswar, nothing has happened.
No,
Bhubaneswar CP filed by the husband 13.1 petition is pending at Bhubaneswar.
Yes, ma'am.
So,
CP is pending, ma'am.
pending,
CP is state, ma'am.
So also otherwise, strategically also, Khordha is less burdened with this kind of case.
Yes, ma'am.
So, I mean, it is a win-win situation for the husband. Tomorrow, day after, or Monday, when do you want?
Tuesday. Yes.
Tuesday. It is submitted by, এটা লিখি দেবে, এটা কত নম্বর item? 2 number. Your name, sir?
SK Gowda Lodge.
SK Gowda. से जो Lorded Council लिखी ले, appearance? S. Priyadarshini, along with Mr. SK Gowda.
Your Lordship, S. Subhadarshini.
S. Subhadarshini. So he has made it Priyadarshini. For the Learned Council for advocates, petitioner, opposite party, Mr. Jitendra Samantara. Tara taku kon kale? J. Samantara. It is submitted on behalf of the Learned Council appearing for the. You are for the petitioner wife, for the petitioner wife that she agrees for the petition filed under section 125 CRPC pending at Bhubaneswar to be taken up at the family court, by the family court, Khordha, if the court directs so. The Learned Council, Mr. Samantara, appearing for the respondent, opposite party husband, submits that the 125 proceeding, upon 125 ta proceed karilani kouchanti to?
Yes.
Upon fail kouchanti ki 125?
125 wife is filed.
Tale upon se proceed kale upon kona how you are prejudiced?
Then much more difficult setter se transfer kariya pai chahuchunti. It is difficult, that is a far distance, my lord. So for 125 re bi se sethi karuchunti, that is not a
in the 125 proceeding, preposition in the 125 proceeding, evidence has
within district TRP is maintainable before the district judge.
That is the 408.
408.
Hey, paribo. TRPC to seta ko decision evidence has started. Evidence has started. Recording of evidence has started. Para. Having had Learned Council for the parties, in view of the wife agreeing for the 125 CRPC proceeding to be taken up at Khordha, if is directed along with the CP filed by the husband under section 13 of the CPC, Hindu Marriage Act, HMA. So Samantara shall obtain instruction regarding both the matters to be taken up at Khordha. So if you agree also, I can direct that you file a petition before the Honorable District Judge and it will be immediately done.
And it come Tuesday, my lord.
Yes, yes. Mr. Samantara has time to obtain instruction, list on consent list on Tuesday ke tarikh 6/5/2025. don't go by the version of the conducting counsel.
Yes,
At times they don't realize that what is happening.
much okay.
Yes, next.
Item 3.
Item 3,
You are Mr. Raj.
MK Swami.
Mr. MK Swami. Mr. MK Swami for the petitioner.
Last occasion notice was issued through family court Bhubaneswar 1, my lord, and a report has come. Drug D, my lord.
Yes, Mr. Rautre. You are appearing here.
My lord, I am through. My lord, my lord.
ଆପଣ ଗୋଟେ ମୋବାଇଲ କାମ କରୁନି ଆପଣ କୋଉଠି
Am I
ଅଛନ୍ତି?
audible, my lord?
No, you are not
Lord, I
audible.
have been instructed. My lord, I have been instructed to appear for the opposite party husband, my lord.
The learned counsel, Mr. Binay Bhushan Rautre, submits that he has instructions to appear on behalf of the opposite party husband. କେବେ वकालतनामा फाइल करिवे?
By Monday, my lord.
He seeks accommodation till Monday to file wakalatnama. Wakalatnama shall be taken on record, scanned copy, updated list. Upon filing of the wakalatnama, the registry. Stop कर लिखो तो upon filing of the wakalatnama, the registry shall indicate name of the learned counsel appearing for the opposite party in the case brief as well as the cause list. Yes, Mr. Swai, केबे आनिबे?
Interim order continue, my lord.
केबे चाहुचंदी एटा?
After vacation also interim.
Yes, Mr. Rautre. Se कहले after vacation.
My lord.
भी कोन राजी गले? एमती husband wife के राजी होना आपण मन जो भाव राजी होचंदी adjournment ପାଇଁ. Why the husband and wife are not agreeing? The कौन लिखले?
In the divorce proceeding, my lord, the consultation was going on, my lord.
See, exactly. You have got absolutely. I mean dot on the point. Why they are not agreeing when you are agreeing so much for adjournments? There can be adjournment in the relationship also for some time, some cooling period and all these things. Why fighting out? The learned counsel for the appearing parties seek adjournment on consent list on vacation पर देवे date आया 30/6
Interim continue.
interim order dated
But 22/1/25.
22.01.2025 shall continue till the next date. Could you, Mr. Rautre, could you hear the date? 30/6. Yes.
My lord.
Yes.
Item 4.
May I please, Your
Mrs.
Lordship?
Susuma Rani Sahoo for the petition.
May I please, Your Lordship? In this case, I am the petitioner in this case, ma'am.
There is a problem, Mrs. Sahoo. The report is they are unable to, the signature obtained from the recipient
Ma'am.
is illegible. That's a mistake in our part. But what can be done?
My humble submission before Your Lordship, before the family judge Baripada, I have already appeared, and the certified copy also I have submitted before this honorable court. If the Lordship has directed, serve the copy through the council of the Baripada council, problem is solved, ma'am.
The office note dated on 30/4/2025 put up by the registry indicates the following. In view of the signature of the receiving person in the AD not being clear, sufficiency or otherwise of the notice cannot be observed. Stop. The learned counsel appearing for the petitioner submits that pending proceeding, that is CP number 314 of 2024, before the learned judge, Family Court, Baripada, Mayurbhanj. The opposite party husband, he is
The husband filed the divorce petition before
filed by the husband. One likely. Opposite party by the husband. The notice can be served on the learned counsel through the court. So to make it sufficient. Requisites for service of notice to the court shall be filed two sets of requisites shall be filed. How much time you will take?
within a week I have filed.
Within 7 days. Within 7 working days kar diyantu. Chutti thiba kon. Within 7 days. The requisites shall be forwarded to the learned judge, Family Court, Baripada at Mayurbhanj, to be served on the learned counsel, to be served on the opposite party through the court. The learned counsel appearing for the opposite party in the proceeding shall also be served. The service return shall be forwarded to this court and placed on record. List after vacation.
My lord, interim order may continue.
Date karantu. List on 3/7/2025. Interim order to continue. Interim order dated 11/3/2025 to continue till the next date. Registry to do the needful. Yes.
Deeply obliged.
Item 5.
Over, my lord.
Yes, please. We are Mr. Mohanty.
SK Mahapatra.
Mr. SK Mahapatra for the petitioner.
Pass over, my lord.
Yes.
Pass over, my lord.
Why pass over?
I have not kept the file.
This is only for sufficiency of notice, though it is after notice, but it is in the nature of a order. Upon cause list dechanti. Look at the cause list, why it is listed. Mr. SK Mahapatra for the petitioner. Office note put up by the registry indicates the following. Office note dated 29/4/25 indicates the following. Regarding sufficiency of notice issued to with the OP number 1, registry shall obtain updated track consignment. Stop. Also shall verify if any learned counsel has appeared on behalf of the OP number 1. List on 14/5/2025.
Kindly.
I hope you followed what I have said.
Kindly give a short date. This case will.
The shorter date, insufficiency of notice. So repeated listing doesn't improve the service. Rather, you should give sufficient time so that after you should check all these things.
This case will disposing.
The notice is served on 24th of April at 6 p.m. Only 24 means 6 days, so 5 days rather. If you exclude 24, it's 5 days. Today's first May. कौन लिख ले? हाँ सेटा सरला था डेट कर देले तो yes
That is
yes
May it please your lordship, I'm appearing on behalf of my senior S. Patnaik. Your lordship,
your name madam
your lordship P. Agarwal.
Miss P Agarwal on behalf of Miss MS. Soma Patnaik for the petitioner.
Yes, your lordship. Your lordship.
Mr. Mahapatra, who is I see? Mr. J.K. Mahapatra for the opposite party. Yes, what do you say, madam?
Your lordship, we seek for a short adjournment.
Mr. Mahapatra, give a date. Give a date.
possible after before vacation or after?
After vacation or before vacation?
Your lordship. Yes, your lordship.
Sorry? Could not get you what you were saying.
Your lordship on 18 June.
18 June. Next, in those 4 days, everything, make it 25th. Give some space actually. Yes, Mr. Mahapatra, on consent, appearance, the learned counsel for the petitioner. 6 accommodation. On consent list on 25/6/2025. Yes.
7.
May please your lordship.
Mr. Milan Kanungo, senior counsel, instructed by Mr. S.R. Mahanti. S.R. Mahanti for the petitioner. Mr. Sanjeev Swai, AGA for the state. Yes.
Well, here, I am challenging.
Yes.
This is a matter regarding challenging the show cause notice issued by the certificate officer, that is page 239 and 18.
Yes.
The notice is under challenge.
Yes.
Saying that. But there is a provision, if he is not agree with the liability, then he can file a petition under Section 8 of the OPDR Act.
Yes.
Instead of filing that, he has approved this honorable. And
No, that's because-
interim order has also been passed on 29/10/2024. But
So you are saying the interim order may continue and the OPDR court may, because if the interim order is not continued, then there is no point in remitting the matter.
No, it will take its own course to decide there.
Yes.
So
unless
he has to admit or he has to
correct. Suppose. So at least the interim order can continue till a decision is taken.
Interim order that can also be.
My lord, I'm not challenging. My lords, what my learned friend is saying, my lords. My lords, I'm challenging the very inception of the OPDR proceedings against me, my lords, because the officer is without jurisdiction. The certificate officer. My lords, what had happened, my lords? The Tahsildar decided this matter against us. By that time, the Tahsildar had been denuded with the powers vested for decision adjudication of mining matters. It was with the mining officer. Now he himself says that I don't have the powers, but still he goes on to decide that yes, you are to pay this X amount.
He has said he has no power.
Yes, my lords. He has said you go before the competent authority.
Please refer.
My lords. The inference is that, my lords. Thereafter, the appellate authority says you go before the. I'll just let me explain it to your lordship.
Yes.
It starts from 207.
It starts from 207.
No, I wanted Mr. Swai to see that. That he has admitted that.
Yes, my lords.
All these things can be raised before the.
No. It is pending.
But Mr. Swai, the other difficulty would be,
Yes.
can the certificate officer enter into competence of Tahsildar or mining officer?
If you say certificate is defective, can decide.
No, competence. Certificate may be defective. One, you are right in your submission.
Yes.
But perhaps only the answer that read court can say, superior court can say that yes, Tahsildar is competent or the mining officer is competent. And maybe in fact, Mr. Kanungo's argument is not that they are denying the liability, they are denying the adjudication.
No, my lords, I deny the liability.
No, please, it's while saying so, I said they now as of now they deny the adjudication, they dispute the adjudication by the person having no authority.
No jurisdiction. Yes.
So how does it benefit the state? Rather, state should be interested. It should be made by the authority having jurisdiction.
That is true, Lord.
Yes.
But in that case, counter will be
Just
required
before
to-
he starts, why lordships may kindly see page 209 of the
No,
brief.
Mr. Swai, why counter? Because in merit, you still the mining officer.
Yes.
What is the demand now?
More some crores more.
Some crores.
And that has been stayed by this honorable court.
Huge amount, more than 700 or something.
700 crores.
No. Zero लगे दो चेप्टे Well, that has been stayed by a division bench of this honorable court.
He has all the zeros looking at you. He can believe his eyes that you are appearing in a matter where 7,000 or 700 crores is not there.
Only if you are looking at
The demand.
Yes, yes.
it is too well.
But let me explain. The demand has also been stayed by your lordships.
Yes.
On the letter of the government in the division bench. On the letter of the government, this is an order.
In another case.
Your lordships, let me finish.
Mining matter is a division bench matter.
My lords, here, if your lordship sees the paragraph 2 of the order of the division bench, my lords, your lordships, he submits without prejudice to his contention that the Tahsildar has been denuded of power. Demand notice dated 13th April 23 stood issued. His client participated in proceeding arising out of the demand notice. Impugned is order dated 18th March 2024 made by the Tahsildar confirming the demand in a situation whereby office letter dated 29 December 23 had itself said as reproduced below. Further, it must be noted here that during the lease period, no record of any unauthorized extraction in the particular quarry of Dankari BSQ 1/4 is available. And that is exactly why your lordships stayed the impugned order at paragraph 6. Anyway, my lords, that is a different, that will be adjudicated. This certificate case is based on that demand, which has been stayed by your lordships. Further, if your lordship sees page 209 of the brief, my lords.
No, in fact, without seeing this order, my discussions with Mr. Swai was this only.
My lords.
Because if the state wants to collect this amount, at least they must get it done through a
Exactly,
authority.
that is my case.
Person having authority.
I have to be heard by the mining officer. The Tahsildar himself says, I am not the competent authority. The competent authority is the mining officer.
I mean, the lawyers will be happy if the state, that's another way of looking at it.
That
Mr.
is
Swai,
true,
Mr. Kanungo, they are all happy that now Mr. Swai doesn't have to do anything. He simply say, yes, will initiate a proceeding by the mining officer.
And it has to follow. If this
because now suppose this read court in division bench will adjudicate whether who has the power.
Well,
then that's the only issue that can be answered.
That can be answered. Now today they themselves say that I don't have the power. The competent authority is the mining officer. Then the appellate court also says the mining department.
Regarding amendment, there is a question. It's a question of fact and law. I mean, once amended, it is amended. So I think. So, Mr. Swai, you take instruction.
Yes.
Let them file a. And when
instruction is enough. If because now after this the division bench observation.
Yes, sir.
So the certificate case, when you are saying that is the same demand. So the certificate demand is also I think it doesn't
unless there is a final adjudication subject to appeals.
Yes.
They cannot initiate certificate cases at the fag end, my lords, if I refuse to pay and other things, my lords.
Appearance lecture. It is submitted by the senior counsel that the petitioner challenges the
certificate case.
Notice dated 2/9/2024.
Yes, sir.
And the certificate proceeding video certificate case number 5/2024.
Yes, sir. Certificate case number 5 of 2024.
Stop. He submitted those 2/9/2024 into bracket annex so and so. Annex 18. Is a notice in the certificate case number 5 of 2024 The challenge is to the lack of jurisdiction of the authority passing the original order. That is Tehsildar. That order is at?
Tahsildar's order is at page annexure. Annexure 15, page 20.
Tehsildar Dharmasala.
202. 200. It starts from 200. This is the letter by which he has communicated us.
Dharmasala pertaining to Sairat case number 39/2015-16. तो तहसीलदार लिखले नि ऑर्डर डेटेड 27/3/24 ता पेज 200 रे अछि देखि परिबे 215 सैरत केस नंबर 39/2015-16 a Blackstone query that is a Blackstone query BSQ lecchunti Blackstone query number 1/4 Dankari Blackstone query number 1/4 Dankari DANKARI. It is submitted that post amendment of the minor mineral concession rules, the Tahsildar lacks jurisdiction and the mining officer, deputy na kona mining officer.
The mining officer is the
Jajpur. Mining officer Jajpur is the authority having jurisdiction.
Competent authority.
Is the competent authority having jurisdiction. The whole process of recovery and demand has proceeded with a misconceived authority of the Tahsildar. Stuff. The Learned Senior Counsel then refers to the order dated 31/1/2025 passed in WPC number 25529 of 2024. Wherein the present petitioner the petitioner has challenged the demand notice
13th April date.
13th April 2023.
Yes, ma'am.
On the ground that
the same was illegal and without jurisdiction.
Same was illegal and without jurisdiction being done by the Tahsildar. Having been done by the Tahsildar. Issue notice along with this order. The Learned DG upon advance copy served appears and waives notice on behalf of
notice.
Sorry. The Learned DG in response submits that he shall obtain written instructions and if so advised may file counter.
Yes.
Copy of the order dated 31/1/2025 served on the Learned DG is taken on record.
We'll serve it. One of the interim order may continue.
Interim order dated
29/10/2024
shall continue till the next date of hearing.
Obliged.
On consent when?
On 1st July.
1st July 2025. List on 1st July 2025.
Obliged.
Item 8, my lord, one passover.
Passover 8.
9.
No, please. In response to the order dated 25/4/2025 passed by this bench, the Learned Registrar Judicial has put up a note. The note dated 25/4/25. extract of the relevant portion of the note is quoted herein. On page 2 re on going through the report submitted by by both the dealing assistant up to by the superintendent. Para. In view of the office note that in view of the note of the learned registrar judicial, the fact remains that not fact remains that it has to be observed that notices have not been served on the respondent number 1, the learned counsel. The appearance CG Mr. Your senior panel.
Yes.
Mr. Bhavani Shankar Raiguru, B.S. Raiguru, Senior Panel Counsel for Union of India. The learned senior counsel appearing for the appellant submits do the needful. आपण मॉडिफिकेशन पे गोटे फाइल करंतु काली काली आसले हबो ना केबे करि परिबे
काली सोमवार दिन आई विल फाइल
अच्छा ठीक अछि को ऑर्डर सफिशिएंट हेतिला मन पड़ुछि आपनकर apart from modification, you have to seek leave to take fresh notice. Every time I should not assist you, Mr. Raiguru. You have to come up with your ideas. Senior panel counsel. Needful for seeking leave to take fresh notice. And modification of the order dated 11/12/2023. It is submitted, he may be accommodated.
On Monday, I will file by day after tomorrow. By Saturday, I will file.
Monday माने कितने 6 तारीख ना 5 तारीख लिस्टन 6 5 20 25. So after that it has to be
6 तारीख दे अधिक है 5 तारीख को
5 आसु 5
by Saturday I will file.
5 yes.
Item 10.
So then it has to go to that bench. Because unless you file it, yes.
May please,
Mr. Suraj Mahanti for the petitioner. Mr. Debraj Mahanti, AGA for Lekhive.
My limited
is 1, 2, and 3.
My limited grievance before Lordship.
Yes.
And my original case was dismissed for default due to non-prosecution.
Yes.
I have.
You are the petitioner.
Yes.
You are the petitioner.
Yes. I came to know when I have received the demand notice by the Annexure 2. Immediately thereafter, I have filed the CMPL before this Hon'Ble Court, and that matter is pending. I pray for Lordship.
The original case before High Court.
Yes. The division bench.
Then how a second read petition is maintainable?
No. Said that I have challenged the against order of the award passed by the court.
What is the read petition that was dismissed for the non-prosecution?
Yes.
It was with the same prayer or a different prayer?
Different prayer.
Then how it is related also?
After dismissal of the case, they have initiated a certificate case. Opposite party initiated certificate case for that. In certificate case, that
CMPL you have to move.
Yes,
otherwise nothing can be done.
Yes, I have filed the CMPL.
So you move that.
No, CMPL फाइल करछि
move माने सेटा आपण कोर्ट रे कहिबे जेमति आजि कहउछन्ती रिट पिटिशन टा सो यू हैव टू मूव द कोर्ट फॉर CMPL.
No, CMPL हम फाइल करछि
सेटा व्हिच बेंच
पावर नहीं पास द इंटीरिम ऑर्डर
that is division bench.
हां से
nothing can be done.
नहीं CMPL रो पावर नहीं तो ए जो इंटीरिम ऑर्डर पास करिया पे फॉर रजिस्ट्रेशन पे फाइल करछि माय टिकट जस्ट my limited grievance till disposal of my CMPL application.
No, that cannot be.
This is the procedure.
These kind of powers to High Court do not have, as far as my perception. This I will pass orders controlling the other proceeding. Then Mr. Another third prayer that you pass orders in this proceeding.
Or your lordship.
You see, you have to seek relief in the pending proceeding. That's the only way out.
No, that is your
If
lordship.
you do not want, it will be dismissed. It is your choice.
मो कहया कथा तो ये जो अच्छी पर्यंत पेंडिंग वो तो सब कलेक्टर दैट सर्टिफिकेट प्रोसीड
You see,
your lordship में direct
CMAPL, filing of CMAPL, dismissal. Dismissal has its own consequences. Dismissal of a writ petition by the order of a division bench cannot be taken care of by a coordinate bench, division bench, much less a single bench. That's the first part. Second part, CMAPL has to be assigned, go to the assigned bench. I cannot take it up. So no scope of me taking it up. Now the third issue, whether I can pass orders in those matters, dismissed writ petition, CMAPL, due to difficulty faced by the petitioner in the writ petition. Answer is no.
No, it is a OPDR matter. OPDR is the assignment of your lordship. OPDR matter. JPL file करची.
You are not getting, sir. You are not. Either you are not getting. You are not. You see, the order challenging the demand has been dismissed or not?
No.
Then why you are filed CMAPL?
No. Decision non-prosecution ହେଇଛି.
Whatever, sir. That is the reason of non-prosecution on merits, but it is dismissed.
Or your lordship, ଗୋଟେ ଛୋଟ ମୋର certificate के साथ ये रे मोस्ट appear କରୁଛି. Let him wait till the final decision of the CMPL.
Have you made that prayer? Has he refused? Have you made that prayer? I am not an assisting court of a OPDR ADM. You must understand what you are doing.
No.
Have you made that prayer before the ADM? He has refused to wait. Then you can come. Seek mandamus.
Already
you see, the read court is not assisting the ADM to proceed in a matter. You are agreed by an order, or you are agreed by which order of the ADM?
No, I have the sub-collector order. Sub-collector, yes.
Whoever, ADM or sub-collector.
The read court limited grievance is it?
Sir, the grievance is limited. I have understood. Is it that I have not understood? Then you say that, then so that I can repeat, I can explain you again.
You
think that I have not understood? Have you made that prayer before the sub-collector not to proceed and he has rejected? So that order straight away.
Let it go day after 2 Monday.
Your prayer is different.
File
kindly look at the prayer, read the prayer.
Pardon, my lord.
For everything and every time the court cannot assist, that's the problem.
Item 9 interim order continue. Item
interim order थी लगी. Interim order dated so and so shall continue.
Question by Magici.
Let us not go on a drawing room conversation confined to the writ petition. It doesn't look nice, and more so in YouTube. That judges and lawyers have started drawing room conversation. So your prayer is to quash the demand notice. That demand notice is after the division bench dismissing the challenge.
And after, yes.
Everything no.
That is correct.
So that I will file that. It is submitted that in the petition of praise for quashing of the demand notice dated 29/1/2025 in connection with certificate case number 12 of 2024. It is submitted that the challenge to the original demand was made by the petitioner in a writ petition, WPC number 11521 of 2012, which was dismissed on 4/7/2022. Thereafter, CMAPL number 91 of 2025 has been filed for restoration, recall. It is submitted that the said CMAPL is yet to be taken up since the said order dated 47/2022 has not been annexed, this court is not in a position to refer to the same.
I have annexed that order.
The
Annexed one.
कौन लिखले सेटा काटी दियो. The order has been annexed. This present petition marked as annexure 1.
Yes, 10.
The order dated 4/7/2022 was passed by a division bench. WPC 11521 of 2012 लिखचंती. देखिए लिखियो ना बोलवा ले. हाँ देखिए the party ने भी लिख दे Indian Paints. It is submitted that the petitioner is facing difficulty after dismissal of his challenge. Para. In considered opinion of this court, after dismissal of the writ petition WPC number 11521 of 2012, the petitioner has to find his remedy as far as the challenge to the original order impugned in the said WPC 11521 of 2012. The learned counsel seeks accommodation as paid for list on
Tuesday, Wednesday.
7/5 କହୁଛନ୍ତି 7/5 20 25.
Yes. ଏଇଟା ଯେହେତୁ CMPL ନାହିଁ ପ୍ରୋଭିଜନ ଏଣ୍ଟ୍ରି ମଡ ତ ଆମେ ସେଟା କାଇଁ
ସେଟା ମତେ ବୁଝିବା ଦରକାର ନାହିଁ. I can also record because it is recorded in YouTube also that you have to move the particular authority sub-collector for suppose sub-collector now refuses that prayer. You have a cause of action to come to High Court. That much of assistance I can render. I have already advised you. You have not annexed.
Readings भी नहीं.
The petition. The petition doesn't disclose.
Yes.
Any order or any
Readings भी नहीं.
direction by the sub-collector. If the petitioner has moved the sub-collector for stay of further proceeding in the pending certificate case.
Yes.
Yes.
Item 11.
11, your lordship, notice has been made sufficient. Response number 1, but response number 2 also it has been sufficient, but she has expired in the meantime.
Mr. Satyasindhu Kashyap, senior panel counsel for the appellant. Mr. Who is there? Anyone for the respondent? Opposite respondent blank or diyantu. Appellant respondent blank. The learned senior panel counsel seeks accommodation to take steps for substitution of R2 since deceased. Respondent 2 since deceased. How much time?
3 weeks.
3 weeks पर और chapter vacation पर जीवा हो रही है.
ये नहीं सर.
कौन लिख ले? As paid for list on 3/7/2025 steps for substitution be taken as undertaken. Yes.
12.
Mr. Padhi, you are appearing in this matter. 11. Muted, sir.
Item 12, Mr. Santosh Samantara is with me.
11, Mr. Padhi.
Kashyap is appearing.
Yes, my lord.
So Padhi, DSGI, PK Padhi, DSGI, along with Mr. S.S. Kashyap, senior panel counsel, SRPC. Yes, next please. 12.
Item 12, they can serve the copy of the same.
Well, copy by na.
No, copy.
Petitioner none. The registry in response to the order dated 21/4/2025. Appearance लिखिए. Petitioner none. Opposite party Mr. PK Party TSGI along with Mr. Samantarai. कौन कहले?
Yes, SK
Mr. Samantray,
Samantarai CG Senior Pendant Counsel.
CGC.
For OP number 1, OP number 2 to 6, none. Para. None appears for the petitioner when the matter is called. Registry has put up a note in response to the order dated 21/4/2025 passed by this bench to intimate the petitioner, indicating that the enrollment number or the mobile number is not mentioned in the Wakalatnama. Therefore, they have not been able to. Therefore, the registry has not been able to contact the learned counsel. The matter is pending since 2018. Notices were issued in 2018. On 4/7/18, none had appeared for the petitioner. For a continuous period of about 7 years, learned counsel for the petitioner has failed to appear. So, it seems the petitioner has lost interest in prosecuting the matter. Para. To grant further opportunity, list on 5/5/2025. ଆପଣ 6 ଚାହୁଁଛନ୍ତି? ଠିକ ଅଛି 6/5/2025. The matter shall be proceeded with in absence, irrespective of the learned counsel for the petitioner not appearing in the matter. The learned DSGI submits that the copy of the petition has not been received in his office. या तो कहउछंती या कहले
My lord.
सो आ गोटे कोर्ट को पळेलेनी सर ए कोर्ट रे ना साइड रे गोटे कोर्ट अछि होते
I'm sorry. Yes.
नहीं नहीं अछि
Yes, yes.
इट्स yes no in fact submits that he has not received, has not been served in his office. So I'm in a way peremptorily to 6/5 एटा कर दियो टू बी मेंशन कर दियो एटा कुछ आछी एटा आर नेचर कोन ऑर्डर्स तले ऑर्डर्स तो ऊपर आसीबो ठीक अछि यस
Hatin,
yes Mr. Jena,
My lord, in this case, I am appearing for opposite party.
he said that he have taken consent and sought adjournment.
No.
Mr. Arjun Sethi for the petitioner. Mr. Pitambar Jena along with Mr. R.K. Mahapatra, senior counsel. For the opposite party, number Mr. Jena, opposite party.
What?
One, apna state hochandi Mr. Sethi. ଆପଣ OFDC ପାଇଁ
Yes, your lord.
senior counsel OP number 2, 3 and 4.
Yes.
Mr. Ansuman Sethi for ASC additional standing counsel for OP 1, 5 and 6. You are having copy of the brief. Wherever you are not having, you mention so that they can solve you. If at all there is any difficulty, these are old matters. Learned counsel for the petitioner Mr. Sethi submits that he may be accommodated to obtain instruction and advance arguments on consent list on 23/6/2025. He has said for you agree to 23/6 or you do not agree? Before vacation you want?
After vacation.
ठीक है 23/6. The name of all your counsel appearing for the petitioner Mr. B. Senapati and associates be deleted. Or you are along with say Poleleni Kode. Maybe deleted. ସେଟା କାଟି ଦିଅନ୍ତୁ ସେଟା ଜଣା ନାହିଁ ସେ କୋଉଥିରେ ପାଇଁ କାହା ଅଛି the name of the earlier council ଯୋଟା ଅଛି ସେ ପାର୍ଟଟା କାଟି ଦିଅନ୍ତୁ yes
14
yes
I'm on virtual mode, Malad.
yes please.
I humbly pray that it come Monday. I'm not feeling well.
Kali Prasad Mishra, senior counsel, instructed by Mr. Reddy for the petitioner.
Maybe taken up Monday or old matter.
DSGI for and it's apanankara central force, central police
CRPF.
force.
CRPF.
DSJ along with Mr. Manoj Pati, senior.
So DSGI along with Mr. Manoj Pati, senior panel counsel.
My lord.
MK Pati, senior panel counsel for the opposite party. We agree for a date. The senior is requesting for a date.
Any day convenient to my learned senior.
Tuesday, Monday, Tuesday, madam.
So the court master suggests.
Convenient to lordship. Convenient to lordship.
7-5 habo.
How 7-5 how sir?
On consent list on 7-5-20-25.
Oblige.
15
Mr. S.D. Das, senior counsel, instructed by Muhammad Faradis for the petitioner. For the opposite party?
I'm for the opposite party number 2, Your Lordship, the official liquidator. Piyush Panda on behalf of Mr. A.P. Das.
Just a sec. Item 15, 15. Anyone for OP1, OP3?
We are there for IDC, Your Lordships.
Acha.
But Sitri Simane bodhe ye kori nahanti. IDC is no more there. IDC
No, we have substituted, my lord.
OMC.
As per the order, my lord, earlier we have substituted it, and my lord, OP number 4 is already at a party, the Odisha Mining Corporation. We have.
But that actually we did not know unless that consolidated cross title is not there. We cannot file the Vakala.
No, there is some confusion, Mr. Paradis. In fact, my brief they have shown consolidated to be the earlier cost title, but your title is there. Your serve a copy.
Yes, we have.
What you have filed is there on record. So, but the learned senior Miss Ratha is saying that she is not aware of that. कौन लिख ले? Appearance लिख ले? ना लिखी ना दिया अच्छा. Senior counsel, instructed by Mr. Muhammad Paradis for the petitioner. Miss Ratha, senior counsel. Pammi Rath, senior counsel, instructed by
P. Mohanty, Your Lordship.
P. Mohanty for OP number 1. Kindly please repeat.
Piyush Panda on behalf of A.P. Das.
Mr. Piyush Panda on behalf of A.P. Das for OP2, official liquidator. Upon chahle bracket re bhi party na likhi paribe. OP3 no one is appearing or need not appear. Managing Director AVS spinning.
The AVS spinning down
Is no more.
Liquidated. No, I got. So that's the question, that need not appear or no one is appearing. No. What should be?
Yes.
OP3 none.
Yes, he may be called, but
says the you have to find out ki nahi chanti tale. You are aware.
I moved to old file. I will provide.
So you can, Mr. Paradis, you can implement whoever has taken up ABS. Get that instruction. Kaun likh le?
My lord, it is not necessary.
3 none submitted by the learned senior counsel, Miss Ratha, that she doesn't have a copy of
we have
the amended cost title. Mr. Paradis submits that he will
they have
file
the copy, my lord.
Eh?
Yeah,
They have a copy.
obtain the
So that computerized copy would have.
first.
But it is the same call lekha hai.
Substitute.
OP4 is.
Instead of substituting, they have added OMC.
So one by nobody can represent today.
So OP1.
So OMC has taken up IDCO.
It called totally all its sister companies, everything is totally merged with the OMC.
OP1 ta chhad diyo. OP4 likhun. OP4 ଆପଣ ଏଟା ମାର୍ଜିନ ଲେଖିଥାନ୍ତୁ consolidated cost title ଦେଖି ଲେଖିବେ or else if you go to the old cost title confusion ହେଇଯିବ ହେଲା Mr. Senior Miss Ratha OP4 OP2 ପାଇଁ ଲେଖିଲେ official liquidator sorry
Piyush Panda
on
behalf of AP Das.
AP Das A.P. Das 2. It is submitted that by the learned counsel Mr. Paradis that he is not aware of the entity that has taken over the OP number 3 ABS Spinning Odisha Limited, which is under liquidation.
I was aware, my lord. I was aware.
Sabu sale ହେଇଯାଇଛି, and I think even dues and everything is there in that sale purchase agreement and everything.
And
So if that is seen actually देखा गया OP1 or OP4 रो किसी liability बाहरी they all have a claim is OP number 3, but they have to bring the rightful person now, whoever took OP number 3.
So can you I mean get that instruction? Mr. Paradis seeks accommodation to obtain instruction. By what time you got that instruction?
My lord, what I pray, my lord, the RT applications at Annexure 9 shows after the liquidation process, my lord, the money is with the ITCOL now, which is merged with the OMC. All the money which is
what he says,
yes,
after the liquidation, it has been paid, or I mean, it is there. It is already paid. It could be a scenario.
Yes.
I think it's getting it a little wrong here to understand that ABS as such was a separate entity. So we sold off our shares. But who takes over the liability? ABS was supposed to be run by that new entity.
Purchased it.
Yes, and he took all the liabilities also. So even if I get some money for my shares, this is not my liability. So only when that share purchase agreement and everything comes on record, that will have a clarity. So it's not like you sell your share purchase agreement, so that means it's not a.
So let me record that your submission. So that will clarify the whole thing. Paradis, FARADS. After instruction. It is submitted by the senior counsel, Ms. Ratha, that the erstwhile IDCO, now taken over by the Odisha Mining Corporation. IDCO जोड़ा लिखे into bracket OP number 1 had some shares in the corporate entity OP number 3 ABS Spinning A.B.S. Spinning Odisha Limited. Subsequently, those shares have been sold. The liabilities of the OP number 3 ABS Spinning has been taken up by another entity. As such, there would be no subsisting demand against the erstwhile IDCO or the subsequent entity taking it over. That is Odisha Mining Corporation.
May I just point
Yes.
out, I find that there is an old affidavit also on record when ITCOL was there. But 18/2/20 ସେଇଠି complaint ସେଇଠି
Flag P.
ସେଇଠି ITCOL at that time had also explained the position because ସେତେବେଳେ ITCOL ଟା ଥିଲା.
The learned senior counsel refers to the order, the affidavit dated 18th February 2020, filed on behalf of the erstwhile OP number 1
by the petitioner.
by the petitioner.
Petitioner by way of rejoinder.
It's a Prabhakar Raut.
They are making a claim against the official liquidator. Right. Agreement. Agreement.
He says that it is a subsidiary of ITCOL.
Yes, the counter agreement copy ta bhi achi. The order of the company judge.
This particular 18-2 affidavit filed by the petitioner.
It's filed by the petitioner.
So it's
filed
by the petitioner.
In reply to the counter which we had filed on 3/2017.
Was he deputed to work in ABS spinning from ITCOL?
No, he was, I think, transferred. Chitra transfer hotala.
No, kindly say annexure 1.
Their employees.
Annexure 1.
But annexure 1 only refers to Baripada spinning mill and its management.
Yes, we appoint the top of the page.
Correct, but they have conducted the interview only.
Yes, it is the appointing authority, the ITCOL.
Your Lordship will see, I mean, jo counter that we had given, clearly we have mentioned that as per the agreement which happened when all these spinning mills were actually sold, because there are 3 spinning mills were actually sold, then there was an agreement clearly saying that all the assets, liabilities and personals of BSM and ASM would be taken over by the subsequent purchaser. An entire, winding up.
Now he is 73 years. So what do you want? You want us monthly salary and allowances?
Arrear salaries, my lord. There is a arrear.
So
there is an.
Was there a demand before the liquidator?
Yes, my lord. There is the earlier order of this Hon'Ble Court which I have quoted in the affidavit, which is at fact P, my lord. At paragraph 1. Page 2, my lord, there is a towards before the paragraph 2. He is entitled to get his service benefits. This court disposed of this petition pending directing ABS pending Orissa Limited, which is no more there, my lord, to pay all the service benefits of the petition till the superannuation. My lord, considering all this, my lord, this Hon'Ble Court directed to pay all his dues.
The whole thing is they in fact have admitted in the rejoinder that for the initial dues they had approached the official liquidator and they have received it. Today he's asking, so today he's asking for enhancement, the same process. Because winding up even my shares and everything has been realized. The whole money is with the official liquidator.
What is your stand of the official liquidator? Or you want instruction because the junior is not there?
Lordship, from what I can refer from the counter affidavit that we filed, it says that an amount of rupees 1,64,000 has already been disbursed to the petitioner in this case.
No, that he admits actually, petitioner. So petitioner says some more amount is due.
So
what is the response of the official liquidator?
For that, I'll have to seek instruction from the
learned counsel for the official liquidator shall obtain instruction regarding its response to the claim of the petitioner of the amount that he claims apart from the amount of rupees 1,64,000 received after liquidation from the official liquidator. Received from the official liquidator after liquidation. Stop. How much time?
2 weeks.
2 weeks means it goes beyond vacation. List on 3 If anything possible, then you discuss, and because he's now 73, 74 years of age, so he's only, hoping for something may happen, some miracle. And if his dues are not, Mr. Paradis, if his dues are not attributable to that period of engagement, because your own stand is also that ABS has been owned up.
Yes, ma'am.
So beyond that, ITCOL, you show that engagement order, ITCOL cannot be saddled with that liability. because it is refers to the management committee. Yes. It's like if you are recruited and deputed, then it's fine. But you are selected and posted in ABS. And earlier you were working in some government office in Puri. From there also you have not been deputed. In the roads and building, R&B. If you mark the address in that Annexure 1, so that is not address of IDCO. Your official address is given, R&B Puri. So that way also, I mean, this hope of getting something may not be there. So at least the petitioner should know that. If the matter is kept pending, then there is no point. He has his hope of getting something.
My lord, after
So if at all you could have made a consolidated claim, then apart from 164, you could have got something. That's another thing. That's another way of looking at it, you can say. You also, I mean, if possible, you talk to the petitioner. Date kar dele? Yes, yes.
16.
Ms. Ratha, you also have an instruction if anything is possible.
Yes,
No, not exact. I am seeking your assistance regarding anything from the liquidator.
But I think what has happened is he is probably claiming on the basis that if this scale of pay would have come and then I would have got, but
by that time, actually, the problem is the company is no more there.
they're a sick company. So one has to probably see that the underlying legal principles on which he is claiming, because the official I think when he lodged the claim, official liquidator, according to the whatever orders with the company court must have passed, has found
Paid him 1,64,000.
Yes. And obviously, official liquidator cannot do anything beyond what the company order is or whatever the situation was.
Definitely. He's more kind of a, custodian, parents patriarch. Yes, next.
Both parties have agreed to take just 1 week more time. Your Lordship.
Yes.
I was having such
Ms.
a
Ratha, senior counsel instructed by Mr. Mohanty for the petitioner. You are?
Saroj Maharana on behalf of Mr. Milan Kanon.
Saroj Maharana, instructing counsel. Mr. Senior Mr. Milan Kanon go. Senior counsel Mr. Milan Kanon go. On consent list on date kebe kouchanti?
Next week.
District date hai paribo dekhantu.
No.
9/5/2025.
17.
Mr. S.B. Mohanty for the petitioner.
May I appeal?
Yes, please.
I'm appealing
during pendency of the my lord writ petition, it is a case of revised pay and consequential revision of pension, EPF pension, along with some gratuity.
Yes.
My lord, during pendency of the writ petition, the my lord petitioner personally made the district transport manager OP number 2.
Yes.
So considering his extreme old age and the old age ailment, so they have been gracious enough to settle the claim. Accordingly, advised the petitioner to file a representation. So accordingly, as to the advice of the DTM, the petitioner has filed a representation on 24/4/25 with due acknowledgement. So I pray.
You wait for let the matter be adjourned, or you want withdrawal?
Last dispose of because with the TTM. So on their advice and consent.
But that is not part of record actually. That's not part of record. I can't rely on that. I mean, I can't refer to that. I may rely, but I can't refer to that. Debe se doubt. Members affidavit sagara diontu.
Put affidavit kori.
Memo kori de.
Memo kori de.
Ne seta affidavit re diontu. Let it be on record. Kebe ko anibe?
Mu
Sombara.
Sombara.
Mr. Subharan Social Month lekle. Mr. Amitabh Tripathi for the opposite party. It is stated by the Learned Counsel for the petitioner that during pendency of the petition, he had approached the opposite party authority for redressal of his grievances. Considering his age and ailments, the authorities have been gracious enough to settle to suggest a settlement for which he has approached the authority by making a representation. The representation is to be brought on record, supported by an affidavit, He seeks accommodation till Monday as prayed for list on 6-5. Monday माने 5 तो 6-5 on consent list on 6-5 20-25. Yes.
Problem.
18.
Mr. After recess.
My lord, Mr. Rotha is on his legs and another court that's
Mr. Mahapatra.
My lord, sir, I'm appearing for opposite parties.
So he is requesting after recess.
Recess, may I pray, my lord, next week, any day, my lord,
my lord, Mr. Rotha is requested to pass over. That's why. Urgent is there. I mean,
Okay, ଆପଣ ଯଦି ଆପଣ ଆସେ at least ଆଥାନ୍ତୁ ଯଦି ଆପଣ ଯଦି ରହିପାରିବେ because it will then fast matter after recess. Yes, next.
19.
My lord,
Yes, Mr. Panda.
the petitioner grievances, he has challenged the order of dismissal passed by the disciplinary authority as well as confirmed by the appellate authority. And the challenge is order dated 30th July 2016, Annexure 8, page.
No, is not there actually. This is after notice matter.
Yes,
so the both side has to be heard. After recess. Let us call it after recess. So rest of the matters after recess, any mention?
34.
3-4.
Next week ended or after vacation?
Sorry?
Next week ended or after vacation?
Which for the other side?
In Lolaton Das year.
এটা তো ଆପଣଙ୍କ ନାଁଟା
SK Raut man.
SK Raut ଆପଣଙ୍କ ପାୱାର ନାହିଁ 34 sorry. So SK Raut. Mr. Das, anyone appearing for the other side?
Gautam Mishra, I will intimate him.
So Lolaten to Das କଣ ଲେଖୁଛନ୍ତି?
Anyway, I don't know him.
এটা ତାଙ୍କ absence ରେ କେମିତି କରିବେ? Let the matter reach. Your matter, any matter, Mr. Das?
Item 25 I was praying for.
25. It is noted. It is noted. Yes, that order will be passed. Yes.
Mention item 23.
Yes, 23.
And the type, there is a change in the Gramya Bank structuring. That Odisha Gramya Bank.
Since yesterday.
Yesterday. So I want
Since
to.
Since today rather. Since today.
I may permit it, I will file IA Monday so that the cost title will be amended. That is the only thing.
Mr. Nanda, you will be appearing for the new entity or you do not sure?
No, I am appearing for the Odisha government. No, that I have to take instruction. So for the change in structure.
So that order has to be passed. When the matter is taken up, that I will pass that order.
The council has taken time for amending the first title.
Yes.
Let it come matter 13th or 14th.
14th May.
14th.
Yes.
I'll file the IA. And also, I have a copy to.
Yes, yes. Yes. Pass over.
Item 8.
Item 8, I mean,
Lordship, in this matter, perhaps they have asked the Lordship allowed the intervention petition.
item 8, I am
What is
in,
there, but I'm ready to.
Yes, Mr. Sahu.
item 8, I am in virtual mode. That we have filed an intervention petition. I am the selected SSG group under the advertisement.
Yes.
We have been selected and the by order dated 6/11/2024. So we have not been included as a party in this writ petition. So therefore, we have filed this intervention.
First, last occasion, Lordship, include party, but last occasion, perhaps that application has been allowed.
No,
You
application.
don't have any objection, Lordship.
It has not been allowed.
No, last occasion it was noted, Mr. Sahu's notice submissions have been noted,
Yes.
but in your absence it was adjourned.
It was adjourned.
I don't have any objection. Let them.
Mr. S.K. Dalai for the petitioner, Mr. S.K. Swai AGA for the state, the opposite parties 1 to 6 and 8. Jaha achi cause title se repeat hejibo. Mr. N.K. Sahu, advocate for intervener. The learned counsel for the intervener. Mr. Sahu, learned counsel appearing for the interveners, reiterated his submissions as noted in order dated 23/4/2025. Have you served copy of the intervention?
Yes, Lordship.
The copy of the intervention has been served, IA number 667 of 2025. Copy of the intervention application, IA number 667 of 2025 has been served on the learned counsel for the petitioner. It is submitted by the learned counsel, Mr. Sahu, that the intervention be allowed in view of the fact that by order dated, कितने कहले?
6/11/2024.
6/11/2024. The intending interveners have been selected as
the fair price shop dealer.
Has been selected as fair price shop
dealer.
Shop dealer.
Yes.
A shop dealer. SUB shop dealer.
Shop dealer.
Fair price shop, Lordship. SHOP.
dealer.
Shop. Dukan.
Acha.
Fair
Shop
price
SHOP.
Yes, shop.
SHOP.
Shop dealer.
For the year 2024-25.
The learned counsel for the petitioner fairly doesn't dispute the said aspect that the intending interveners have been selected. Having heard learned counsel for the petitioner and the learned applicant, petitioner interveners, petitioner intervener, the learned counsel for the petitioner in the writ petition, the intervention application is allowed. IA stands disposed of. The interveners shall be implemented as opposite parties 9.
9, Lordship.
How many intervener?
One, Lordship.
One intervener.
As of OP number 9. Copy of the pleadings shall be served on the learned counsel for the appearing for the newly added OP number 9. Consolidated cost title indicating the amendment in the cost title, including the interveners are OP 9, shall be filed. How much time, Mr. Dhani?
More I can file, Lordship.
Filed within 3 working days.
Yes.
When do you want listing date?
Next week, Lordship.
Date कर दियो तो.
Next week, we have to
Mr.
find
9/5/20 on concept. Yes, Mr. Sahu, you said
that they will serve the copy of the writ petition. We have to respond to the allegation made in the
right.
I don't have any allegation. He is a stranger, Lordship.
Why?
He can assist, Lordship.
से टिके अधिका समय चाहूँगी बधे.
नहीं, that taking advantage of that.
We have been appointed.
That's why, Lordship.
Yes, Mr. Sahu, you suggested date.
After reopening.
After reopening, Lordship. I am at again, Lordship.
Again?
Selection process यदि challenge करचुंदी ताले they don't have anything to say against.
I am the Gram Panchayat. I have
on consent list on 12/5/2025.
Lordship. Entry mode to continue, Lordship.
Entry mode till the next date. 13 कौचुंदी.
13-13
13/5/2025 13/5/2025 entry model dated so and so shall continue I eta dispose of hela pore eta retray eta order hochi
Yes, grateful.
yes
obliged.
Item 18,
so JK Ratha senior counsel instructed by Mr. DN Ratha for the petitioner.
Item 18, my lord. Just before launch, my lord, my senior was there and my senior was asking for like next week.
Mr. Ratha, can you give a date next week?
Again.
Mr. Ratha, can you give a date next week?
My lord, any date your lordship may give it next week, that is the 8th or 9th like that.
Not 9th, my lord. 8th.
8th
is okay.
on the learned counsel for the learned counsel for the matter was passed over. The matter was passed over on the learned counsel for the opposite party. 6 for accommodation. On consent list on 8/5/2025.
Sir, I've got a prayer.
Yes, please.
Can it be taken as a part-heard, my lord? Because otherwise, my lord, I am facing little difficult.
But part-heard system has been amended. The rule has been amended.
That is.
In fact, when a new assignment comes, so many councils mention that we have completed, and it has to be argued again.
My lords, only because of to come in the earlier part of the list. That's
no.
not
The one thing I can tell you that this after notice matters, whoever is reaching on the same date, not reached same day, is taken up as leftover next date. So it automatically goes up.
I cannot have anything else that.
Yes.
Because
it is retaining its position, so to say. So maybe you can say the list is for almost at least for 2 days. So, but he says that it's on 9th. He has some difficulty. So let it be on 7th.
Yes,
Let it be on 7th. So if it is not reached, then it can be. It can reach on 8th.
Yes.
7th kar diyo.
Oh, bless.
Yes.
19,
18 Mr. appearance लिखिए Mr. लिखिले Mr. आपन को नाटा sorry I forgot please. Mr. M.R. Pradhan. Mr. M.R. Pradhan on Mr. Dayananda Mahapatra, Senior Counsel, along with Mr. M.R. Pradhan. Mr. Pera AC.
Oh, bless.
VC Rachel. Yes.
Madam, here this petitioner challenges the impugned order of the disciplinary authority passing order of dismissal dated 30th July 2016.
So could you take instruction on that? That if you go to the extent of saying that the punishment will be sustained because you have 2 grounds.
Yes.
You say that this is disproportionate, shockingly disproportionate.
Yes.
That the quantum of punishment on the last date of retirement.
Yes.
The penultimate day of retirement is disproportionate because he has lost everything. The entire service benefit has gone. But yes, you are challenging, rightly so. I mean, you are well within your limits. I mean, rights to challenge the disciplinary proceeding. But it's a midway. Suppose you accept the imposition of the punishment regarding this quantum of punishment, it will be compulsorily retired with all service benefits. So Mr. Udgata will take instruction on that. So is it possible, Mr. Udgata?
I'll take instruction.
Yes. But I mean, you have to be proactive here. Because simply asking them, they don't realize.
Exactly.
I mean, these matters you have to be proactive.
Rightly, my lord has also advised this writ petition suffers from 2 things. One is number.
No, I simply quoted your submissions last occasion. Though it is not recorded, but somehow I have some. I remember that, so that is how.
Minor. That's all. The date can be.
Yes.
15th May. Will it be okay?
May not be minutes.
नहीं 15 भूल सकती है ये पर एक है
But a chance niyantu. He will be satisfied for listing. At times, if the matter is listed, the learned counsel is satisfied. at least.
15th final.
This is item
Item 19.
Mr. S.N. Ponda for the petitioner, Mr. B.N. Udgata for the opposite party. In terms of the earlier order dated 23/4/2025, no, not in terms of. When the matter is taken up, the matter, it is submitted by the learned for the petitioner that petitioner may accept. Should I, Mr. Ponda, likely difficulty achi ki?
No. Again,
Petitioner may accept the punishment of compulsory retirement with all service benefits such as pension without challenging the disciplinary proceeding and imposition of the punishment. अपन जो फास्ट रे पढ़ले accept the imposition of the punishment of compulsory retirement in place of dismissal from service. In view of such submission, the learned counsel for the opposite party bank may obtain instruction. As it would be possible not to enter into the merits of the disciplinary proceeding as well as imposition of punishment apart from the quantum of punishment. On consent list on 15 May 2025.
all right.
Item 20.
May it please your lordship. My lords, item 20 is a writ petition filed by the state challenging the order of the National Food Commission, my lords.
Prabhu Prashant Behra for the petitioner. Where are the opposite parties? This is an after notice matter.
Yes, ma'am. The last date, your lordships, has observed that opposite party number 6, 7, 8, and 9 are being erroneously added, and it was directed us to take steps for deleting them. But my lord, no steps has been taken. I have today morning I have sought instruction. My lord,
Got it.
My lord.
Opposite party blank non likhi diyantu. The learned additional standing counsel for the petitioner state refers to the earlier order that passed by the coordinate bench. Order dated kar debe 3/2/2025 coordinate bench. To submit that, he has sought for instructions regarding deletion of the opposite parties 7, 8, and 9, and may be accommodated further. How much? Kebe anibe?
My lords, within 1 week I will.
But 1 week pore karantu tale.
My lords.
12 tarikh na kebe?
Yes, my lords.
13/5 कहउचंती 13/5/2025.
I'm obliged, my lords.
Yes. आज पेज पर लिस्ट ऑन 13/5.
Great.
Arjun Hitler, right. Mr. Miss H. Sahoo on behalf of Banshidhar Bagh, Senior Counsel. Mr. S.K. Nath for the opposite party. The learned counsel for the adjournment is sought for. Adjournment is sought for by the learned counsel for the petitioner in absence of the learned senior arguing counsel. The counsel for the opposite party objects for adjournment, saying that the matter has been adjourned on several occasions. To grant further opportunity, list on 9/5/2025 on consent.
Item 22.
Mr. U.K. Samal for the petitioner. Who is the other side? Mr. Vibhuti Bhushan Misra. Yes, Mr. Misra, Mr. Samal.
Yes, ma'am. May I please, your lordship? The
Kindly speak to the microphone. ଘୁଞ୍ଚି ଯାଇଛି ଟିକେ ଆପଣଙ୍କର ଡାହାଣ ପଟକୁ ଟିକେ ମଝିକୁ ନେଇ ଆସିଲା.
my lord, the petitioners
Yes.
were the
What is the status of pleadings?
status
Status of pleadings is complete or anyone because it's after notice. So any of the parties they want to file any further pleadings.
there is a order
Yes.
dated 27/9/2022.
Yes. That is order number.
Order number 10.
Yes, I'll just find it. Yes, order number 10.
There is specific direction was paragraph 6.
Yes.
Learned CGC of the opposite party.
Mr. Samal, just kindly share it with Mr. Misra.
Yes, I am having a copy of it.
Or you can look in that paperless, what I am looking at. No, sir, searching when Mr. Samal is submitting, so I thought that we should wait for you.
No, my lord, I am also having a copy of it.
You start using the paperless.
Since it is a bulky file, so I am.
No, so that's the advantage of paperless. You can just simply scroll. Go to the bookmark. Bookmark. Click that WPC. Then there is a bookmark. Then at the top you will find the orders. So any order you will find and you can scroll it. Suppose you find order number 13. In fact, order number 10 is not bookmark, but 13 is bookmark. So if you reach 13, then you scroll up to 10. In fact, the youngsters could assist.
Order number 10.
10. 27 na 22. Bookmark is 13 is there. You find order number 13.
124.
Just scroll up. You'll get order number 10. He's referring to paragraph 6.
Yes, ma'am.
Yes, kindly go. Yes, Mr. Samar.
Since learned CGC for the opposite party dispute as to the continuous engagement of the present petitioners as brake van license porter to do the job handling of parcels at various stations under Sambalpur division, he is directed to file an affidavit with supporting documents with regard to the engagement of the present petitioners prior to 31st of March 2017. That is from the date of their initial engagement till the date 1st of March 17. As admitted in the counter regarding the number of days worked by each of them in the preceding year.
Yes.
So also money paid to them towards rendering service of handling parcel at various stations under Sambalpur division. There is a mention in the counter that after 31st of March 17, the present petitioners were never engaged to do the job of handling of parcel. To the contrary, bills as brake van license porter for the month of April 2017, bearing signature of the station master and the chief booking supervisor, has been filed in form of rejoinder affidavit at Annexure 11. Mr. K.C. Karal, Learned CGC, is directed to explain in form of an affidavit as to under what circumstances such bill was prepared but no payment was made to the petitioners if they had not worked beyond 31st of March 2017. Since
Yes.
Mr. CGC makes a submission before this court that after 31st of March 2017, the said job of handling of parcel at various stations under Sambalpur division is being done through local arrangement through station master, he is further directed to file detailed affidavit as to who were doing those jobs of handling parcel after 31st of March 2017 till date and details of payment made to the concerned laborers with their names. List this matter in the week commencing from 17th of October 2022. Compliance affidavit be filed under on filing will before the next date of after serving copy of the same of the Land Council for the petitioner. Pursuant to this order, a affidavit has been filed, but not in compliance with this direction. Here the claim is this much, my lord. The petitioners are licensed
Sir, there is a change in counsel.
Yes, there is change in counsel.
So I think Mr. Misra,
My lord.
Now affidavit has been filed. Mr. Samal says that it is not in terms of those paragraphs where he has specifically mentioned, started reading from paragraph 6 to 8. So the courts, the order of the coordinate bench is very clear actually. Very clear.
But there is another order that was passed on 13/11/2024. Probably.
Yes. Time was taken by your
24. From the order speech.
13/11.
11/24. That is taken up to hydrogen from Southwell and County Council on behalf of Mr. A. Southwell and Government of India. Submits the previous council in the panel of Government of India, and Mr. Rautre has instructed to replace the Mr. Rautre undertakes to file appearance.
And that you can file, whether it is Mrs. Rautre or Mr. Misra, that it is, you can file that.
In view of soft submissions made by one council, one council for the Union of India is directed to do the needful.
Because in case of, in absence of the council authorized, the matter cannot be taken up. Or it can't be attributed that the other party was heard. So that is the difficulty.
When the Honorable Court found that the order has not been, the affidavit is not the order number 14.
Yes.
710. 710. The Land
Mr.
Council.
Can you look at order number 14?
The London Council for the Union of India is directed to file an affidavit stating therein the working status of the present petitioners.
Okay. So, is there any order referring to the affidavit after it was filed?
Yes, referring to the affidavit, the Honorable Court directed to file the status.
No, actually that doesn't refer. Any earlier order where this affidavit as directed by the order number 7, order number 10 has been referred to.
That has not been reflected in the subsequent order.
So then I am observing that. Mr. Misra, you have filed your appearance.
Yes, I have already filed.
I will draw your lordship's attention to the order number 3, my lord.
Order number 3.
My lord.
Yes, 3.
As an interim measure, it is directed that the petitioners number 1 to 10 who are working under the East Coast Railway as brake van license
shall not be disengaged.
Shall not be disengaged from their services till the next date.
Yes.
And the interim order, this interim order has been time and again has been extended by this Honorable Court. And they have also filed an application for vacation of stay. This order is pending before this Honorable Court. But still then, they are not paying. I am entitled per day, per working day, I am entitled for 222 rupees only. They were regularly paying. The moment I filed the case for non-payment of arrear salary for 3 months, they stopped paying. Since 2018, we are discharging our duties. Still then they are not paying.
No, for that reason also that affidavit will take care of that. Para 6, 7 and 8. Because I mean, it doesn't appeal to common sense, Mr. Misra. Suppose your client turns up and tells you that the without brake van porters, we are managing the facility.
Yes.
Then the only way is that mechanized. And no here mechanized handling of.
We have outsourced the system.
Why?
So because
how can you?
The present petitioners are railway porters, my lord. As per the
you may outsource. You have outsourced employment, but not the work.
My lord.
Outsourcing of the employment and the work are two completely different things. A, B, C, D are working. You have outsourced and now X, Y, Z, L are working. How can that happen? The outsourced employer can engage A, B, C, D. And as far as porters are concerned, this activity in railway stations.
So
it is not only. I mean, this is repetitive and work.
But that mistake they have committed.
Suppose now you say that the brake van service has been abolished.
No, my lord, my humble submission is.
No, my lord, you are saying to every proposition, it's a hypothesis.
My lord.
Break ban facility has been abolished, suppose you say. So then there is no porter is necessary.
My lord.
So, but how can you say that they are menial worker and they are not been paid the minimum wages also. They are paid for according to their work.
Yes.
My lord.
Whatever work they are doing, that much. They may earn more, they may earn less. That's another thing.
My humble submission is the petitioners are licensed porters, my lord. They cannot be utilized as break ban porters, my lord. Licensed
Sir,
porters.
who is asking you to utilize them?
They were utilized by local
you see, but it's a chicken egg problem.
That was
they say that we are being. Then are you yourself the officer? The station manager is himself picking up those parcel.
No, my lord, but
so that is the reason, sir. They don't claim anything beyond to be break ban porters.
They were claiming wages, man.
Wages, definitely. Wages for their work. Wages for their work. And why should you replace a porter with a outsider? I don't know. In fact, the whole scheme is very.
Seeking regularization. Actually, there is no post for break ban porters.
Are they seeking regularization?
I made clear I am not claiming any regularization. My prayer is very limited. You are paying 2,222 per day up to March 2017. Thereafter, you have not paid. You kindly pay my daily wages. I am discharging the very same duty.
Mr. Kindly look at the prayer. You have a copy of the brief, or you can use
Yes,
that.
I am having it.
Page 14. There is no such prayer actually.
But
They simply seek the wages.
they are also at the same time seeking questioning of the order of the.
My lord, previously.
Sir, order if you remove from their service, according to you, they are working with you and you pass an order of removal from service. They have challenged that. So then why you are worried? I don't understand this also. Suppose that there is an order passed by you disengaging them.
We have not disengaged them.
Then why you are bothered about that? They are seeking their wages. You pay them their wages. And if at all you are engaging some, either you take a stand. Break van service is no more available in Indian Railway. Fair enough. But you cannot state that they are licensed porters. You admit there is no dispute. So why should you engage others?
Well, licensed porter cannot be utilized for the purpose of this service.
So the rule. I mean,
that is there.
Don't make a statement.
No, that is there. I have annexed it to the.
So that rule where it is said that licensed porters cannot be engaged.
My lord, Annexure 4 is the impugned order. Impugned order says there is no such post called break ban licensed porters. That is the reason for which my representation
let it be.
Has been rejected.
Sir, you can term them as break ban licensed adjudicator. Instead of using the name judges, you can term them the adjudicator.
Series of
managers. Like somebody is a floor manager, he manages cleaning the floor. So that you can term them anything.
My lord, the last occasion, the Honorable Court directed for the second affidavit. In fact, they furnished a report. A government school teacher has been engaged by the local management as a
disputed questions.
Disputed. I have annexed the document. Therefore, the Honorable Court directed them to file an affidavit. A government school teacher, somebody's name has been mentioned. They have come to this Honorable Court and file affidavit. We have never engaged by the local administration, by the station manager as break van license porter.
We are not maintaining any role. We are not taking.
You have filed.
Sir, how do you, sir? What kind of relationship you may call them brothers also? That's not a justiciable issue. Not to be adjudicated, sir. They are concerned with them being paid the wages. That's it.
My humble Swami,
sir, they are not asking how do you term them. You suppose you say that they are divisional managers of divisional manager porters,
yes,
like the railway manager, divisional manager East Coast Railway. So you term them as divisional managers of those licensed divisional managers of break ban. So, does it, what turns on that? Mr. Mishra, my simple query to you is that what turns on commission regarding they being treated as something. Because maybe you are briefed like that, they want say regularization, where there is prayer. If you want to regularize them, you regularize them, that is your business. Suppose now you are disengaging them to those who are not regularized or not engaged by you. So they are challenging that. Suppose. That is how I say suppose.
But they were issued license for porter. They were supposed to handle the.
Sir, by repeating 10 times that they are licensed porter, does it improve? Because we are not discussing.
How can they be
Sir,
engaged?
Mr. Misra, we are not discussing that you engage. They simply seek their wages to work under you. You don't like them, but you have to be transparent to that extent. Suppose you do not like them, bring that affidavit, let it be adjudicated. Why you do not like them and for you don't give them the work.
That is not the.
So you look at the prayer. I don't know what you are able to make out from prayer. I cannot at least. Look at the prayer.
Yes, sir. My humble submission is.
See?
They worked till 2017 April. We have cleared all their dues. There is nothing remains outstanding, my lord. They are.
Mr. Misra, you can have a replay of this quote. You have categorically a few minutes ago said we have outsourced the work to somebody.
Up to 2017.
Why you know? Why under which provision? When the licensed porter is available, you will outsource the work of porting to an outside agency.
Because we cannot keep the licensed porter in the service of breakfast service. That is the restriction.
Then the learned counsel for the opposite party submits that the work of porting of the PORT, the verbiage, work of porting of brake van has been outsourced to an agency since 2017. A further affidavit by the opposite party shall be filed indicating the details of engagement of such outsourced agency, doing the work of porting on.
Agency, I don't know exactly.
Sir, it's a serious courtroom conversation.
My lord,
you have to stand by.
We have outsourced.
Yes.
We have outsourced.
Whatever you do, you give the details. How you even I can record that you have disowned the statement and said that we have simply outsourced. It doesn't matter how you are doing it. You may come up with a case that God has now intervened. I don't know, but you must tell that to the court. बहुत जिनस भगवान करो ये चालू नहीं की. Suppose you say that we have outsourced rising of sun to outside agency. Earlier it was under our control. If a statement can be made.
Probably I could not place it properly.
No, very clear. You are so clear that is how I am responding and dictating the order. Since the things are so clear, no. I cannot change the order at your instance every second. Once you say something, then you say that I disown that statement. Don't do that. कौन लिख ले? Doing the work, the details of payment made to such agency, details of the persons engaged by such agency to do the porting work. How much time, Mr. Misra?
2 weeks time.
ଆପଣ ଯେତେବେଳେ ଜାଣିପାରୁନାହାନ୍ତି ନହେଲେ ୟୁ ଟେକ୍ ମାନେ ଆଉ ଥରେ ମତେ କୁହନ୍ତୁ ଆପଣ ଯୋଉ ବିବ୍ରତ ହେଉଛନ୍ତି ଆପଣ କଣ ଭାବୁଛନ୍ତି ଆପଣ ଆଉଟସୋର୍ସ ହେଇଯିବେ?
After 2 weeks,
ତା ପୂର୍ବରୁ ଲେଖିବେ the learned counsel for the petitioner refers to the order dated order number order dated 27/9/2022, wherein the coordinate bench had directed at paragraph 5, 6, and 7. 5, 6, 7, and 8. For filing of affidavit by the opposite parties as observed in those paragraphs. It is submitted by the learned counsel for the petitioner that affidavit was filed purportedly in compliance of the orders, in compliance of the said order dated 27/9/2022, but without giving the details as directed. Thereafter, another coordinate bench,
Order number 14.
by order dated 7/10/2024, had directed the opposite party to file an affidavit stating the working status of the petitioners. But in response, the learned counsel for the opposite party submits that since he has succeeded the earlier counsel, he may be further accommodated to obtain instruction. Regarding stop regarding stop. It is submitted by Mr. Misra that the petitioners are licensed porters. They cannot be regularized in their service.
They cannot be utilized
They cannot be utilized
as break van porter.
as porters for brake vans. चलला तापरे एटा लिखिले कोटा अर्लियर डिक्टेशन तापरे बुझी पाले ना बुझी पाले तापर लास्ट टाइम देखि दियंतु तापर आउटे ऐड करंतु जोटा लिखिथिले ऊपर the affidavit to be filed by the opposite party shall also indicate the reasons for which licensed porters cannot be engaged as brake van porters. And more particularly, if there is any mandate of any rule or provision. Yes.
Only one line. They were engaged as brake van license porter by the railway department itself. Since when we were engaged, they are not producing the records. Let them file an affidavit stating since when we are discharging the work.
Let us see their response. Somehow the response has not been coming up actually. That is the other difficult part of it. Mr. Misra?
2 weeks, your lordship.
On consent list on, let us take a chance before vacation.
Yes, sir.
As on consent list on 14 2025 15
Item 23.
Mr. S.N. Ponda for the petitioner. Mr. S.K. Nanda for the opposite party. Submitted by the learned counsel for the petitioner and also endorsed by the learned counsel for the opposite party that Odisha Gramya Bank has been merged into a new entity with effect from 1/5/2025. The learned counsel for the petitioner seeks accommodation to file appropriate application for bringing on record the new entity. Tapare likhibe the learned counsel Mr. Nanda appearing for the erstwhile Odisha Gramya Bank submits that he shall obtain instruction and file wakalatnama on behalf of the opposite newly formed entities. On consent list on 14/5/2025.
Item 24.
Mr. Lolitendu Bhuya for the petitioner. Mr. Adam Ali Khan for the opposite party. On consent of the parties, list on 24/6/2025.
25,
Mr. S.T. Das, Senior Counsel, instructed by Mr. H. Mohanty for the petitioner. Mr. Gautam Misra, Senior Counsel, instructed by Mr. Dinesh Misra. Dinesh Patra.
Asim Kumar Das.
I'm sorry, Eke Das, Mr. Asim Kumar Das, Eke Das for the opposite party. On consent, list on 14/5/2025.
26,
Mr. Jagatjiban Pradhan for the petitioner. Mr. Subhankar Das for the opposite party. On consent, list on 26/6/2025.
27,
Connected matter ଅଛି ଦେଖିବେ ନା ଡାକିଲେ କେମିତି ହବ connected ଦିଟା matter ଅଛି same order ହେଲା appearance ଏକା ଅଛି
Item 27, madam.
yes yes
Madam,
please.
petitioner is the wife, unemployed wife, madam.
Yes, who is for the other side? You are Miss Sefali Das.
Madam.
MS. Sefali S. Das for the petitioner. Anyone for the author call to 27?
27,
Yes, Miss Das, what happened?
Medicine report is also there, madam.
Has it
Please for
achieved
transfer
anything?
of- Madam,
Mediation has achieved anything?
petitioners,
Unsuccessful. Mediation is unsuccessful.
my lord.
So, कौन करा जीवो?
Praise for transfer of from family court Jharsuguda to Sundargarh, my lord. On the consent of both the side, it was referred to mediation, my lord.
Correct,
And-
correct, sir. That
But-
correct, madam. That has failed.
But the husband did not turn to, so medicine is, and last order kindly.
None
say
appears for the
totally-
opposite party when the matter is called. Registry shall intimate the learned counsel on record for the opposite party regarding listing of the matter.
Entry order is there.
List on केबे गोटे डेट दियंतु शॉर्ट डेट हेले आरो हे परिबो 8/5 you have difficulty on 8/5/2025 entry order dated
Entry order dated 5/3/2024.
5/3/2024 shall continue till the next date. You are seeking transfer.
Transfer CP filed by the husband, my lord.
So interim order is in your favor actually.
Right.
So you did not want the proceeding to proceed, so you have won the interim order and that is continuing. So they are supporting you. So why not in real life? If they are supporting you in court, then why not in real life? Day-to-day life रे भी support करिया कथा.
3 थर से आसी फिर के जाइए मैं till today he has not paid.
What can be done?
9-10 years.
Let us see the registry shall put up a कौन लिख ले? हाँ. The registry shall do the needful. Yes, please.
28,
Petitioner none. Opposite party blank. None appears for the petitioner when the matter is called to grant further opportunity. Date quorum short date.
15,
12/5 कर दिया. List on 12/5 है.
49,
Lordship.
Yes.
Lordship, I am appearing for the opposite. Lordship.
No one for the petitioner. Your name, sir?
Balram Naik. I am appearing on behalf of Rakesh Beher. Lordship.
You don't have power.
No, Lordship.
Petitioner none. Mr. Balaram Naik on behalf of R. Behera, Rakesh Behera for the opposite party. None appears for the petitioner when the matter is called. You have any idea regarding mediation? What happened?
Your Lordship, may I apprise? On the last occasion, Your Lordship, this Honorable Court has directed for
Unsuccessful.
conciliation.
Unsuccessful mediation. 17/1/25. matters kept pending like that.
Thereafter, your lordship,
To grant
thereafter,
further opportunity, list on 8-5-20-25 अरे पूर्व मैटर भी 8-5 कर दियो जोड़े के अपियर करना है 28 8-5
may I?
yes please yes
Your lordship directed on 25th March 2025 on the last occasion for conciliation before the trial court. Conciliation was held on 29th March.
so you file that memo that cannot be recorded orally if the other side is not appearing.
Yes, your lordship.
Suppose other side is present and you make a submission regarding that, so it can be recorded that both parties are present and they submit this so and so.
Yes, your lordship.
So if you want anything, or you can file that order passed in that conciliation. If at all any filed,
Could not obtain any order, your lordship.
so then don't make a oral submission.
Pardon.
Always try to be, I mean, very what you call particular.
So that's all.
Particular in your approach in a court proceeding. So date dele 8th of May. By 8th, obtain that instruction or copy of that order, whatever.
Oblige.
Yes, next.
14,
29 Gola.
38,
Appearance लिख ले 29 election appearance. Yes. Balaram Naik on behalf of 30 Mr. M.K. Biswal on behalf of Tanmay Misra for the petitioner. Anyone present for the opposite party blank? The learned counsel for the petitioner seeks further accommodation to file a rejoinder in response to the counter by the OP number 2. As paid for list on 23/6/2025. Interim order dated dash shall continue till the next date of hearing.
31,
Mr. J.K. Khuntia, you are there for the opposite party?
Yes,
Mr. J.K. Khuntia for the petitioner? Opposite party blank?
File petition for transfer of the.
Correct. First, I have to deal with the notice.
MI.
The office note put up by the registry dated dated 24/4/25 24/4/25 indicates that the track consignment as at flag F shows that the item has been delivered, postal article has been delivered on 25/3/25. Mr. Balaram Naik and associates have entered appearance by filing Wakalatnama. You are Mr. Utkola Kesari Naik?
Yes, Lordship.
Yes.
Lordship, I want some time to file counter. So
What? Go for mediation. This parallel proceeding offshoots of a CP pending in the lower court. This is Mr. Khuntia transfer of what?
Transfer of the criminal proceeding.
125 share piece.
125.
DB. Now 125.
Although it was filed in 2022, till date not a single pie has been paid as the interim.
So you have filed and you want transfer.
I want transfer. I have filed. Now
So why do you want?
Because my father is staying at Kotak and nobody is there to look at.
So if you are not earlier, where you have filed?
Because I was staying at my village.
Where? Place, sir.
Kendrapada. That is Rajan.
So if you are not paying at Kendrapada, don't pay at Kotak. That's a simple approach in 125 CRPC. You are not going to pay anything. So you agree for transfer also and don't pay. If you have a approach of what is the consequence? I'm just forgetting that term. What is it is a so you agree for transfer because you are not paying as Mr. Khuntia is. I mean the petitioner is saying.
there is no order of maintenance in lower court, Lordship.
Could be the very good reason. Court doesn't listen. You don't pay. So how does it make a difference if you proceed at Qatar? But this requires your proactive. Simply by saying everything yes to your client may not help.
The man is a government servant, retired and getting 50 lakhs to one daughter, one son, and a wife. They have been deserted when nothing has been paid by the opposite party.
Appearance exception. The note regarding non-service of the note regarding unserved notice or AD not received back shall be ignored. ଆପଣ ପାଖରେ କପି ହେରିକା ପାଇଛନ୍ତି ତ?
Yes, Lordship.
ତାହେଲେ ଦରକାର ସେଇଟା. So you have received it ଆପଣ? The learned counsel for the opposite party seeks accommodation to obtain instruction. କେବେ ଆଣିବେ?
Sir, after vacation.
ଏତେ ଦିନ କଣ କରିବେ? କଣ ବା ପଇସା ଦଉନାହାନ୍ତି? ଯଦି ବି ପଇସା ଦଉଛନ୍ତି ସେ ଷ୍ଟେ କରିଦେଲେ ଆହୁରି ବି ସେଟା ଆପଣଙ୍କୁ ସୁବିଧା ହବ. When she herself has chosen to challenge her petition for get
no, I have no.
I mean, not challenge
Only
she herself is seeking for transfer.
Yes.
But chance ଦିଅନ୍ତୁ ଛୁଟି ପୂର୍ବରୁ.
ଆଜ୍ଞା.
କେବେ କୁହନ୍ତୁ?
As your Lordship do.
ସେ ତ ନାହିଁ ସେଟା. ମୁଁ ସକାଳଠୁ ସେଟା ଶୁଣିକି ଖୋଜି ପାଉନି. ଲର୍ଡସିପ କୋଟା ଆରମ୍ଭ ହେଲା 5 ରେ ସରିଲା 9 ରେ.
15.
On consent list on 14 ରେ ରଖନ୍ତୁ. You work on this. These petitions are not to be kept. Sir, you are having so many. Mr. Naik is having so many petitions, cases in High Court. Is this a case to be kept pending? That's the short point I wanted to tell you. Next call करंतु.
32.
Mr. A.K. Sahoo. Sahoo.
Yes, my lord. I am appearing for the petitioner.
On behalf of Lalitendu Misra for the petitioner. Mr.
I am for the respondent. One certain copy may be sought, my lord.
You are Mr.
We learned about the TRP petition.
Gyanarajan Mahapatra कोड़े पढ़ेले आपण तो नहंती. इटा item 32 तो. आपण कर 32. आपण को नाटा कोन कहले?
I don't have copy, my lord. One second.
I will solve it.
List देखि दो. List देखि दो. Appearance हम पचार actually. I am not asking about copy. Look at the cause list.
My name is Jyotirmay Barik. J.M. Barik is there.
Mr. Jyotirmay?
Yes.
Excellent.
May I submit one?
Yes, just a second. Let me note the appearance actually first. Mr. Yes, how on behalf of Lalitendu Misra, L. Misra for the petitioner, Mr. J.M. Barik for the opposite party. Yes.
We didn't serve with any notice, my lord. We learned this about this TRP when they submit a copy of this interim order passed by this honorable court in the court below. That's why we want a copy.
No.
My lord, on 25 March, second notice has been served as per direction of this honorable court. But notice.
Yes, ma'am.
Kindly.
Now I can serve a copy.
Is Mr. Prabhat Barik. Mr. Prabhat Barik, kindly see if any postal liquidates is there in Nijibe. Learned counsel for the opposite party request for a copy of the petition along with annexes and IE. It is noticed that the unserved postal requisites filed earlier are kept on record, are available on record. The learned counsel shall receive the same in the court to be countersigned by. The learned counsel for the opposite party shall receive the same in court by putting his initials in the order sheet? In the office note kar debe. In the order sheet meant for office note to be countersigned by the court master. Yes, when do you want? Agree for a date?
Yes, my lord. Kindly list
15
after
chalo.
vacation, my lord.
Mr. Pradhan,
After vacation.
after vacation, on consent, good a date kar diyo. Please wait, give him some time so that he will, because he's busy here. नहीं से after vacation कहले 15 कही थिले 36 on consent list on 36
My lord, interim order to contact.
interim order dated
16th January 2025.
16/1/2025 shall continue till the next date of hearing.
Obliged.
Mr. Bari, kindly get your copy from court.
33.
Your name, madam?
Elena Acharya.
Mrs. A. Acharya.
A. Acharya.
A. Dot Acharya for the petitioner.
List
Opposite
of the-
party blank. Office note put up by the registry regarding service of notice dated 24/4/25 indicates the following. Neither AD nor undelivered notice to neki pura शेष हो जाए on behalf of him.
Your Lordship, interim order to be continued.
Track consignment. You want transfer of which petition?
Transfer of petition from Barampur to Puri because
So you are for the
I am for the petitioner
wife.
Sunita Satta. Your Lordship, as
Just a second. I have to because you should be updated with the what is the track consignment.
Yes.
Who is the addressee? BK Barik.
हाँ, Vijay Kumar Barik. First requisite was signed.
The track consignment. The track consignment. Dated 24/4/25 kept on record marked as flag B indicates that the postal article was delivered to Mr. BK Barik into bracket addressee on 23/4/25 at 16:08 PM. Since no one was appearing, no one has yet appeared on behalf of the. No one is appearing today. No one is appearing today for the opposite party. Registry shall verify if any learned counsel has appeared on behalf of the opposite party. List on. जी कितने तरीके होची? जी एक. List on 7/5.
Yes.
Interim order dated.
Interim order dated 5/2.
Interim order dated 5/2/25 shall continue
Your Lordship,
next date of hearing. Yes. What do you want?
on 15th May.
No, because unless now I have to take a call on a pass orders regarding sufficiency of notice.
Okay.
So in the pending case, where it is pending now?
It is pending. Your Lordship, first the petitioner has filed in Puri, where the opposite party has one on 13/11/2024.
In this petition,
Yes.
the wife has filed it.
Wife has filed and mentioned.
So she has C6 transfer of CP number 442
Your Lordship, here
from Barampur to Puri.
Your Lordship, the opposite party.
Look at the cost title. Look at the cost title.
From Barampur to Puri.
CP 442 of 2024.
Yes.
So that CP has been filed by whom?
By the opposite party, by Vijay Barik.
Vijay Barik.
Yes.
So he's the husband.
He is the husband.
So that petition is filed under
Yes.
which provision? Seeking what direction? What is the prayer?
Your Lordship.
The 13 petition. So in that case, whether he's appearing, you have appeared in that matter.
No, sir, no, your lordship, because
You have not appeared.
Before that,
No. I'm not asking why you have not appeared.
Yes.
The question is very specific. Have
We
you
have
appeared in that matter?
no, not yet.
You
appeared.
are not. That has been stayed at your instance.
Yes,
So-
stayed at our instance.
So let us see if anyone is appearing. कितने तारीख को दिल? 7/5. You have any difficulty on 7th?
Yes, sir. Yes, your lordship.
So what date you want?
15th May.
15 is difficult because it's the last working day.
Yes.
So the registry cannot do the whatever next will be difficult. You request any of your colleagues, whoever is appearing along with you on 7th, let them be present to what order can be passed on that date.
Okay, your lordship. Thank you. Obliged.
Yes, next.
34.
I want some time, my lord. Mr. Ratha is not over, my lord.
34, you are Mr. S.K. Raut.
My lord.
You mentioned this or what? So S.K. Raut for the petitioner. Mr. Lalatendu Das, who is there for the opposite party? Author call करूँ 34.
34.
S.K. Raut for the petitioner. Opposite party none. Learned counsel for the petitioner seeks accommodation due to non-availability of the arguing counsel. Learned arguing counsel. केबे चाहुचंती?
Next week.
आज प्रेड फॉर लिस्ट ऑन 12/5 कर दियो. बहुत गुड़े 9/5 आज कौन कर दिले.
Interim order continue.
Interim order dated
25/2/25.
25/2/25 shall continue till the next date of hearing. Yes, next.
35.
Mr. J. Mahanti for the petitioner. Mr. A.P. Rai for the opposite party. On consent list on 25/6/2025.
36.
So Amit Patnaik for the appellant. So Panigrahi,
I am for the respondent number.
so K. Panigrahi for the respondent. Yes,
1 to 13.
these two appeals are connected.
Yes, ma'am.
Yes, Mr. Rajdeep Pradhan, Additional Standing Counsel for State.
Second matter, I am for the second matter.
Just a second.
My friend.
LAA 8 of 2012 re time actually. Then LAA 17 re Mr. S.K. Das for the appellate. Mr. Das, you are appearing in the second matter.
Both the matters.
Both the matters you are appearing. It's a S.K. Das, senior counsel instructed by Mr. Patnaik. Patnaik for the appellant. Mr. K. Panigrahi for the respondent. Second matter, what you are saying?
Second matter, I am for the appearing. I am appearing for the 1A to 1E. Respondent.
You are Mr. A. Sahoo.
Yes.
Senior Mr. Tripathi is appearing.
Yes.
Along with learned senior counsel Mr. B.S. Tripathi for respondent A1 ru RA1 na kon gote कहले
A1A to 1E.
Respondent 1 to 1E. 1 to 1E, 1A to 1E.
1A to 1E.
1A to 1E. Because 1 might be dead.
ଆପଣଙ୍କର LA 17 amended cost title କାଇଁ ମିଳୁନି? Yes, it is available. Respondents 1A, 1B, 1C, 1D, 1E. Who is appearing for IDCO? LA collector AAC appear କରୁଛନ୍ତି. OP2 LA collector ହଉଛନ୍ତି Sir Rajdeep Pradhan.
Must be state.
State.
IDCO.
IDCO have their separate counsel actually.
Yes, will.
Did anyone appear earlier, Mr. Das? Any idea, Mr. Patnaik?
No, nobody had appeared.
IDCO is not there in the first matter.
Achha. So in the first matter,
Same notification, arising out of
same notification.
Same
For who are the Mr. Panigrahi, you are for all 1 to
13.
1 to 13. 1 to 13, Mr. Panigrahi. Mr. Rajdeep for 14. But in the second matter, I think IDCO would have acquired land. Because the land acquisition is the behest of the IDCO, these industrial lands. So no, not making a party, why you have not made party? Because if because IDCO, I think, is the requisitioning authority and it goes to the land bank, then it is allotted to the. So that is how the IDCO is the same notification means it's an inadvertence.
Your Lordship is absolutely right. If it is for IDCO, as a person interested, IDCO should have been there in the reference.
IDCO is there actually.
Reference itself.
IDCO is there also. IDCO is there in the second matter.
In the first matter, IDCO is not.
Somehow that is what is also, I mean, either it is there or not there, but it is somehow in one matter and other matter it is not.
It is not there. Arising out of the reference, wherever the IDCO was there, they have added them as respondent.
Can you please see at the reference in the first matter whether IDCO is there? Paragraph 3 is clear. As per the award passed by the land acquisition collector, appellant company deposited the entire awarded amount with the land acquisition collector through IDCO.
Yes, yes. Lord, that I have seen.
So IDCO was there. So as you were right, IDCO was there. But somehow not paid a party.
Should have been.
The first matter lekhontu, the learned counsel for the petitioner instructing counsel, Mr. Patnaik submits that due to inadvertence, Industrial Development Corporation of Odisha, sida ebe ache na change hegala. Industrial Development Corporation of Odisha Limited has could not be made a party. 6 liberty to make IDCO a party. Prayer is allowed. You will carry out correction or file a typed copy?
I'll file that.
You will file an amended cost title, typed copy. He seeks liberty to file amended cost title. Arraying IDCO as impleading IDCO as OP number 15. Leave granted. Amended cost title be filed. Be filed by within 3 working days. List on 6. 6th will be fine. So if you can list on 6/5/2025. So let the second matter be listed because they are same identical. In view of the order passed in LA 17 likhibe, in view of the order passed today in connected LA 8 of 2012, list on 6/5/2025.
Will it be 7th, my lord?
No issues.
7th.
This jaga 7 kora. So in one matter you have to file the amended cost title and take notice also. The learned counsel, but you are not sure who is appearing in the for IDCO.
So normally Pavitra Mahate he appeared. Learned senior counsel he appeared.
Okay. So you just inform if he has instruction.
You can take notice on that.
So that.
37.
Yes. Mr. Panigrahi 7th. You got the date, na? 7th. 7th. Yes. Mr. Sahoo,
Yes.
where is Mr.
And for the appellant, my lord.
Yes. You are Mr. Biswajit Mahapatra or Sahoo?
Associate of Biswajit Mahapatra.
You are SK Sahoo?
SK Sahoo.
So SK Sahoo, that is good. When Sahoo versus Sahoo. Mr. SK Sahoo for the appellant, Mr. GN Sahoo for the respondent. Yes.
The appeal is preferred at the instance of the appellant.
Yes.
Lord. Appellant is the opposite party in the court, and the respondent, mother of the respondent was the
petitioners in the court below. Fact of the case like that, my lord, the land which was acquired in the land acquisition case, my lord, that was originally belongs to one Sriram Gondo.
It is a interstate dispute.
Yes, ma'am.
How this? Where is the provision? Where is the provision? The referral court or a suit will determine.
Compensation, challenging the
correct compensation, but after the you can claim, make a money claim,
my lord,
stating that X has received 15 crores. I'm just giving
yes,
whatever comes to my 15 lakhs.
My lord,
I am entitled for 5 lakhs.
My lord.
That's fine. But you are saying apportionment as far as the claimants are concerned.
My lord, here the dispute is that who he's claiming that the appellant is not the son of the recorded tenant, my lord.
No, kindly start with the reference. It was referred
my lord,
because of the dispute. Kindly look at the reference first.
Annexure 1, my lord.
Yes. Mr. Rajdeep Pradhan, land acquisition collector, LA collector. You are having a brief achita apna pakhare? Yes.
The order arises out of a reference under section 30 of the Land Acquisition Act, my lord, submitted by the land.
No, you may not have to read the entire thing. What you can do that wherever it is dealt with, the dispute, the issue is dealt with, or what was the issue to be resolved before the referral court.
Glance the
Gokul Gardia got it. OP number 3.
My lord.
Yes.
Judgment, my lord.
In favor on behalf of his father, Sriram Gonda.
A compensation amount was ordered in favor of the appellant, my lord. She dispute that she is not the appellant is not son of Sriram Gonda, the recorded tenant, and Sriram Gonda died issueless. And I, being the sister of Sriram Gonda, I am being the class 2 here. As per Hindu Succession Act, I am entitled the compensation amount.
Where are the pleadings? Records have been called for?
Yes, my lord. LCR has called.
So look at the pleadings.
Court of the Civil Judge Sundargarh, land acquisition reference case of 313 of 2013, my lord. Shakuntala Bag, the respondent, mother of the respondent, my lord. She died thereafter. Present respondents have been substituted, my lord. Versus special land acquisition officer, my lord.
I don't find the petition.
Paragraph,
the reference or petition, I am unable to get it actually.
Yes, well, that is it.
Reference
Judgment, my lord. Internal page 3, my lord.
No judgment, but what was the claim that was adjudicated, the reference made, or how it started? Pleadings I want to see.
Yes, ma'am.
And the petition is available, my lord.
Where?
Shakuntala filed writ, my lord. In writ petition, this honorable court directed for a reference under section 30.
Fair enough. See, reference ta kahin?
Seta achi internal page 3, last 4 lines, my lord, of the judgment.
LCR, I'm referring to LCR.
Page 3 of the judgment, my lord.
No, kindly refer to the LCR if you are having it. Because you are reading the judgment, I am looking in the LCR to find out how it started. So Gokula Gardia has got everything. Ki paile ki ultimately.
My lord, the referral court has passed judgment, declared that can only have a glance to the order portion, my lord. The
No, you tell me, sir. If you are reading that doesn't help. You should be on top of your brief.
My lord.
You should straight away tell me who is the beneficiary. All those names when I'm asking you.
My lord, ultimately the
Gokula Gardia got everything.
No, my lord. Sakunt, the respondent got everything.
So Gokula Gardia, what he wants?
Directing the payment of amount of compensation to the appellant of Matrimonial through 3, my lord. He being the son of Sriramaganda. But
Sriramganda's son's name is what?
My lord, Gokul Gadia. Gokul Gadia.
Gokul Gadia is son of Mangalu Gadia.
No, my lord. Son of Sriram Gadia. He had stated.
My lord is not deciding, sir. That Gokula Gardia himself is saying. For receiving the compensation, he cannot become son of somebody else. He remains son of Mangalu Gardia. Mangu, but that's so many mistakes in this election commission voter ID card. As on 15/7/2013, Gokula remains son of Mangu or Mangalu Gardia. How can he become son of? He was born in 1953. After 60 years, he remains son of Mangalu Gardia. How can he become the son of somebody else?
He has filed voter identity card plus ration card, BPL card. In that document, his father has been reflected as a Sriramaganda, my lord.
How can it be? How can it be?
But there is no.
Either it is a birth certificate, contemporaneous document. When he was born, it is recorded birth certificate, or he got admitted school.
My lord,
you see, for getting a ration card or a voter ID card,
all
the entries are made by the person himself. You must understand. All of us who were having these certificates, even Aadhaar also, the entries are filled up by ourselves.
Yes, ma'am.
So no, anyone else. So you can make anyone your father by filling up in the. That's not the point.
But
when somebody born in 1953 for 60 years remains son of one person, how can he become son of another person for receiving the compensation?
My lord, as a son of Sriramaganda, the appellant has sold some property to the one of the respondent, my lord. At that time, they did not raise any objection.
Selling away property by narrating to be God also. Suppose, can one become God?
My lord, the respondent also purchased the land.
You must make a proposition legally tenable.
My lord.
What should withstand scrutiny of law?
So
you are claiming compensation. You are claiming compensation of whom?
Son of Sriramaganda.
Not son of Sriramaganda. He is not the beneficiary. He would have got it otherwise. So you are claiming to the compensation being related to son of Sriramaganda. It is property Sriramaganda.
Yes, my lord.
So you start selling property of Sriramaganda by naming and somebody purchases it. Does that make you the son of Sriramaganda?
My lord, the respondent has purchased the land.
Conveyance.
My lord, the respondent has purchased the land.
No, please don't. We cannot jump around. You are making a serious proposition that since I have narrated in a deed of conveyance of sale,
my lord,
to be son of so and so, I become son of so and so.
My lord.
Does it have any relevance as far as Evidence Act is concerned? That should be your argument.
My submission is
Contemporaneous document is not a sale deed to be executed by you yourself.
in fact, my lord,
You can be
it
son
shows
of.
that the
Suppose there are so many sale deeds, you are describing your name to be father's name to be different. It's a hypothetical question I'm asking you. Can it be said that the father changes on each sale deed?
No, ma'am.
So then sale deed has no relevance as far as fatherhood is concerned or somebody claiming to be legal heir. There has to be some contemporaneous document.
The respondent herself, one of the respondent has purchased the land. But at that time, she did not, if
You
it
see,
was within her knowledge,
purchase of land does not amount to estoppel. Purchasing land of somebody stating to be God, suppose. Is it estoppel? That the person from whom the land is purchased remains to be God, a deity. Cannot be. So make a legally tenable. What was your best evidence? What was your best evidence before the referral court to show that you are the son?
the respondent has submitted one after conclusion of evidence. Respondent has filed some document.
That doesn't.
show
It is neither here nor there. After conclusion of, I am saying you, what is the best evidence? Your answer is after evidence. No. Evidence that was rendered, that you stated in your examination in chief. You have withstood cross-examination that forms legal evidence. So what is the best legal evidence you have adduced to prove your this father to be so and so, so and so? Sriram.
I have relied only BPL card, Aadhaar card and a ration card, my lord.
That is self-serving.
But it was because prior to
suppose you see, suppose some like Sriram has himself given a document. You examine Sriram. He has himself made the BPL card stating you to be son. That's one way of looking at it. But your case is that you prepare everything mentioned down to be your father. Everything.
My lord.
Does it help?
But my lord,
the best. So there is no. It is a case of no evidence.
My lord,
it's a case of no evidence.
That BPL card and Aadhaar card, BPL card and ration card was obtained prior to the acquisition of.
Fair enough.
Land.
That's not the point where it is. Have you examined the person who has issued that he has verified that you are the son? That's the clinching evidence you could have made. Produce the authority who has given you the Aadhaar card, who on doc, who in the doc says that yes, I have verified. He is not son of Mangulu. The other problem is that you are son of somebody on record also. That authority has also to come and say that he is not son of Mangulu, though he has been recorded as son of Mangulu. He is son of Sriram. Let us, second part also you leave it now. But you produced the authority who has issued you the BPL card to say that yes, it has been verified, you are born to so and so. That is how it has been issued. Because the entry in a BPL card is made by you to become a BPL person, below poverty line person. So it has no probative value as far as the authenticity of entries are concerned. It may be a very good card or valid document to say you that you are BPL. You are entitled for certain benefits. So similarly, when you are saying that you produced those cards prior to acquisition of land, you could have produced your birth certificate, school admission register. Even Jatak is also admissible. The Jataka prepared at the time of birth is admissible because it is contemporaneous. But interestingly, also Jataka, the authenticity is a problem because in villages, the eldest of brother's name is entered as father's name. It's a practice.
Yes, ma'am.
So these are the issues you have to answer. So your document you could not prove that your father, and on the face of it, it is produced that your voter ID card says that you are born in 1953 and you are son of Mangulu.
No, my lord, Mangal.
Admission register, school admission register was exhibited as exhibit 8.
Yeah, kindly adjust the microphone.
Yes, my lord. The school admission register of the present appellant was exhibited as exhibit 8, my lord, wherein he is shown as the son of Mangilu, my lord. School admission register, my lord.
Yes, Mr. Sahoo.
My lord.
So
It
now there is a Sahoo trio. Both of Sahoo, judges side. So there is no
my lord, secondary
there is
evidence.
no case.
After closure of evidence, the administrative Xerox copy of the school register was produced, and without
Have you yourself proved your fatherhood? That's the point. So you at least you now admit that there is a school admission register.
My lord, without.
So when you admit yourself that school admission register, you do not produce. There is a provision in the Evidence Act. You have to produce the best evidence. Which section?
Without.
Which section?
Stopel, my lord, your lords.
Best evidence.
Admission is the best evidence. 31, my lord. Section 31.
If the best evidence is available, the party seeking to prove a matter produce the best evidence. Like BPL card, BPL authority will come to the court. You can summon anyone. Court has power to summon anyone. Did you produce the person who issued the BPL card or the Aadhaar card, wherever your name has been entered as son of so and so? You have not produced, not examined. So that opportunity is lost. Now, interestingly, you have your school admission register. You do not produce.
My lord, the respondent has produced the certified copy of the school admission register.
The burden of proving your case never shifts.
After closure of evidence,
the burden lies on you. Burden lies on you to prove that you are son of Sridham. So finding out that whether they produce, they at least come up with a case that there is a school admission register which you have not produced. You are saying that though the school admission register is there, my father's Mangalu, but since it is produced after later on with certified copy is produced, it is inadmissible. So that is one aspect of
custodian of the register manual have not been examined, my lord, in this case.
So if you argue that you have produced nothing, then
my lord,
that's the problem. Here it's a case of complete lack of evidence.
Para 14, it has been vividly described, my lord. Para 14 of the judgment, my lord.
Let me dictate the judgment. Mr. Appearance lecture, na? The appeal has been filed by the appellant challenging the under order section 54 of the Land Acquisition Act, and 1894. In the appeal, the challenge is to the judgment dated 23/9/2015 passed by the learned Senior Civil Judge Sundargarh in Land Acquisition Reference Case number 313 of 2013. Lekhi paribe. Arising out of case number 11 of 2010 of Special Land Acquisition Officer, full form, Upper
Ultra Mega Power Plant.
Ultra Mega Power Project, Sundargarh. ଆପଣ appellant କୋଉଠି substitute ହେଲେ ଏଇଠି substitute ନା ସେଠି ହେଇଥିଲେ
88 ହେଲେ
the appellant, the original appellant Gokul Ganda alias Gardia, as mentioned in the cost title, unfortunately passed away during subsistence of the appeal. And he has been substituted by his legal representatives, namely 1A, 1B, 1C, 1D, and 1E, being represented before this court in the appeal by the learned counsel, Mr. Sahoo. Respondents are not coming up. Private respondents, you are there.
Yes, my lord.
Mr.
Respondent number.
Appearance लिखिए, Mr. Additional Standing Counsel for OP 1 and 2, Mr. G. N. Sahoo, respondent 3 to 9. Hello. The judgment dated so and so was post reference under section 30 of Land Acquisition Act, 1894, made by the Special Land Acquisition Officer, जो अल्ट्रा मेगा पावर प्रोजेक्ट सुंदरगढ़ लिखिले ऊपर है सेठी यूएमपीपी का कैपिटल करते हैं यूएमपीपी. After a dispute arose as the appellant, the predecessor in interest of the appellants, that is the deceased appellant, raised a dispute regarding apportionment of compensation amount of rupees 67, 73, 689 that was awarded with respect to acquisition of land measuring an area of acres 2.980 decimals under Hal Khata number 110 of Mauja Kirei for the mega power project at Bheda Bahal in the district of Sundargarh. Initially, the settlement of compensation was in favor of Gokul Gardia. देखिए लिखिए से कितने कौन पार्टी अच्छी Gokul Gardia for purportedly for acquisition of the land of his father Sri Ram Ganda, son of Trilochan Ganda of village Kirei. Before the land acquisition, before the learned senior civil judge Sundargarh, Sakuntala Ganda was the petitioner. After she passed away, she was substituted by her legal heirs, Sakuntala Ganda, wife of Krishna Kansrali, late Krishna Kansrali, was substituted by legal heirs or legal heirs. ଆପଣ ହଉଛନ୍ତି ଗୋକୁଳ ପାଇଁ
Yes, ma'am. Gokula.
ଗୋକୁଳ ପାଇଁ The petitioner, the appellant being the OP number 3 before the learned senior civil judge in the proceeding. OP number 3 in the proceeding before the learned senior civil judge. Sakuntala Ganda claimed herself to be the sole surviving legal heir of her brother, Sriram Ganda, whose land was acquired. She raised a dispute regarding the relationship between Awadi, Gokul Ganda alias Gardia, and the land oustee, Sriram Ganda. The land acquisition officer, Sundargarh, referred the matter to the civil court under section 30 of the LA Act, 1894. It was the case of the petitioner before the learned civil court that Sriram died issueless, no way related to Gokul. Issueless, no way related to Gokul. But no action was taken by the LAO. But award was made in favor of Gokul, claiming to be son of Sriram. Sakuntala preferred WPC number 24112 of 2013. This court, by order dated, Mr. G. N. Sahoo,
The order is not there.
by order dated dash, disposed of the writ petition, directing the LAO to refer the matter to the civil court under section 30 of the LA Act. After the reference was made, the issue frame है नहीं कि judgment रे. Seems in the corner.
No.
Oh.
No.
After the reference was made and the case was
No.
and the matter was taken up for adjudication. And the matter was taken up for adjudication. Case was referred after the reference. The case was taken up for adjudication. Stop कर दिया तो from the judgment.
The petition was disposed on 10th December 2013, my lord.
10/12/2013. WPC disposed of on 10/12/2013. It was alleged in the petition by Sakuntala that Gokul Gardia manipulated documents like voter ID card, Aadhaar card, and claimed himself to be the natural son of Sriram. Sold some lands out of Khata number 110 to outsiders. impersonating to be the son of Sri Ram. But Gokul Gardia has no right, title, and interest over the property. As the original petitioner Sakuntala died on 5/7/2014, she was substituted as indicated above. Though the OP number 3 reference, the present petitioner, Gokul, filed his show cause denying the claim of the petitioner. He contended that Gokul Gardia and Gokul Ganda, single quotation, Gokul Gardia and Gokul Ganda are the one and same person. Gokul Ganda, Gokul Gardia, same person, he being Gardiyan. Now, not repeat karuntu. He being son of late Sriram Ganda. And entitled for the compensation awarded. He relied on the sale deed. Sale deeds executed by him, describing himself to be son of Sri Ram. He denied the allegation in the petition that he is actually son of Mangulu Gardia. The petitioners, the substituted petitioners, that is legal heirs, examined 4 witnesses, including 1A, the scribe of the will, who have adduced evidence, who adduced, not have, who adduced evidence as PW1 and PW4, and proved 8 number of documents. Mr. Sahoo, now for Gokul, you are also Gokul. Gokulananda Sahoo.
Yes, ma'am.
This is a real problem.
Well, the scribe also has in his cross examination, he has stated that.
Please listen. Now, SK Sahoo. Mr. SK Sahoo.
SK Sahoo.
So, did you examine your mother or someone? Best evidence. Did you refer that you are son of so and so? Anyone from your paternal or maternal side? Because you see, when I'm approaching the case, I'm still with you. It's not that I'm like with. Though you are son of Gokul, he is Gokul, so it's not that way. So you have to be, objective in your assessment as a lawyer also. Did you examine anyone from your paternal or maternal side to say that you are not son of Mangulu, but son of Sriram? Anyway, because now that I was just thinking aloud. The documents such as the voter identity card of OP number 3 was marked as Exhibit 4. OP number 3 into dash present appellant was marked as Exhibit 4. Where they have dealt with Exhibit 4?
Yes, ma'am.
Exhibit 4 by the petitioner. The appellant opposite party number 3 produced voter ID card marked as Exhibit A, Aadhaar card marked as Exhibit B, and BPL card as Exhibit C. The case of the appellant opposite party number 3 is that in all these cards, his father's name has been mentioned as Sriram Gonda. Exhibit 4 टा कोठी डील कले कोर्ट को पैराग्राफ रे देखंतु The Exhibit 4 has been dealt with at paragraph 14, internal page 14 of the judgment, where the voter ID card of the appellant OP number 3 was produced and proved, mentioning him to be Mangulu Gardia, son of father's son of
his father's.
नहीं कौन लिखली ता नाटा कौन गोकुल
मंगल
श्रीराम
श्रीरामगंज
आउथरे पढ़ले सेंटेंस टा तो मो नाटा बदे भूल कर देली हम्म हम्म his name to be Gokul na, his name to be Gokul Gardia, son of Mongolu na. Son of Mongolu Gardia of Mauja Kirei. The said exhibit is also available in the LCR. The court हमें देखिले सीधा LCR है ना court देखिले.
ଶ୍ରୀରାମ ଗଡିଆ ଲେଖା ହେଇଛି ଶ୍ରୀରାମ ଗଡିଆ ମୁଁ ଯୋଉଟା ଦେଇଛି ଭୋଟର ଆଇଡେଣ୍ଟି କାର୍ଡ ହେରିକା ସେଥିରେ
ଆପଣ ABC ଦେଇଛନ୍ତି ମୁଁ ଚାରିଟା ଡିଲ୍ କରୁଛି ଆପଣ ABC କୋଉ ଦିନ ଇସ୍ୟୁ ହେଇଛି the more you Mr. SK Sahoo, if you go detail then there will be a lot of problem.
Sir, Paragraph 17, my lord, of the judgment.
Date ପଚାରୁଛି paragraph 7 କଣ? ପାଞ୍ଚଟା ଆପଣ ଧରନ୍ତୁ ଦେଖେଇଲେ ଭୋଟର ଆଇ କାର୍ଡ, ବିଭିନ୍ନ ଜାଗାରେ ଆପଣଙ୍କ ନା ବାପାଙ୍କ ନା ଅଲଗା ଅଛି, ଦିଟା ଦେଖେଇଲେ, one is exhibit A,
My lord,
ଆଉ ଗୋଟେ
ମୁଁ
exhibit
ମୁଁ
ଶୁଣିଲେ ମାଇ ଲର୍ଡ କେମିତି ଆନ୍ସର ହବ? ଆପଣ ତ କିଛି ହିଁ ଶୁଣି ନାହାନ୍ତି, ଯଦି ଜାଣିଛନ୍ତି ନହେଲେ ମତେ କୁହନ୍ତୁ, this is the question. There are two voter I cards, both are of you. One is, both are issued by the authority.
My lord.
First one, exhibit 4. Second one, another exhibit produced by you, exhibit A.
My lord.
First one, your even surname matches with to be Gardia.
My lord.
You don't change it. Why your surname is Gardia, not Gonda? Reason is obvious. If you change your surname, the consequences will follow. So you have made an alias. First one is Gokul Gardia, son of Mangulu Gardia, born in 1953. The voter I card is issued in 2013. So I'm asking you, what about the exhibit A which you have produced? कौन लिख ले? Mr. Sahoo, the document school admission register is marked as exhibit 8. ଆପଣ କେମିତି ହେଲା କହୁଛନ୍ତି ପରେ ବୋଲି?
After closure of evidence ସେଟା ପ୍ରଡ୍ୟୁସ ହେଇଛି।
ଏକ୍ସିବିଟ୍ ମାର୍କିଂ ରେ କଣ କରାଯିବ?
ମୋର
ଆପଣ ଅବଜେକ୍ଟ କରିଥିଲେ ତ? ଆପଣ କାଉଣ୍ଟର ଆପଣ ତାକୁ ଡାକିଲେନି, ଆପଣ ଏକ୍ସିବିଟ୍ 8 କୁ ଡିସପ୍ରୁଭ୍ କରିବା ପାଇଁ ଡାକିଲେନି, ସ୍କୁଲ ହେଡମାଷ୍ଟରଙ୍କୁ ଡାକିଥାନ୍ତେ, ରେକର୍ଡ କିପରଙ୍କୁ ଡାକିଥାନ୍ତେ। କଣ ଲେଖିଲେ? ଏଲସିଆର ଫଟୋକପିଟା ତ ମୁଁ ଦେଖିକି ଡାକିଥିଲି, ଗୋଟେ ଏଲସିଆର ମୋ ପାଖରେ ନାହିଁ କି? ମୋ ପାଖରେ ଏଲସିଆର ଅଛି, ସ୍କାନ କପି ଅଛି। ଏଲସିଆର ତାପରେ the petitioners, present respondents, produced exhibit 8, produced the copy of the school admission register. Indicating the admission of the appellant OP number 3 in the school, which is 50-year-old public document issued by the headmaster of Kirei Primary School. That was headmaster Kirei Primary School, a public servant, and the certificate was issued in due discharge of his public duty. Serial number 192 referred to Gokul Gardia, father's being son of Gokul Gardia, father's name being Mangulu Gardia. Apparently, the council OP number 3 appellant raised objection to the admission register, but no rebuttal evidence was adduced on behalf of OP number 3 to refute the evidentiary value of exhibit 8. Or to disbelieve its genuineness or authenticity. To rely on the school admission register, the learned referral court referred to the decision of the Supreme Court in 2003 AIR SCW 129. Mahila Bajrangi did through LRs versus Badribai and another. The internal page 15 raj. wherein it has been held that entries in school admission register and school leaving certificate describing deceased as father of the dependent made long before dispute arose can be relied on. The learned court also gave a finding, also observed that as the contention of the appellant opinion number 3 to be correct, that he is son of contention no claim kar diyantu. Claim of he is son of Sriram Ganda. He did not adduce any positive evidence to prove, apart from producing his Aadhaar card, BPL card, and voter ID card. In fact, 2 voter ID cards were produced. The first one being that of Gokul Gardia, son of Mangul Gardia. It has also to be taken note of in view of production of the BPL card, voter ID card, and Aadhaar card, that these documents are issued by the authority as per the entries made by the applicant. None of the issuing authority or any other person were examined as witnesses on behalf of the appellant opposite party number 3, at least to state that he is son of Mangul Sriram Ganda. Having gone through the pleadings in the available pleadings, evidence, materials on record available in the NCR, the pleadings in the appeal, and after hearing the learned counsel appearing for the appellant and the respondent, this court is of the opinion that the order dated so and so, passed by so and so, in so and so, is just and proper, not to be interfered with. Accordingly, the appeal stands dismissed. So, SK Sahoo, you made out a best case. The case is as you receive it. You can't add or extract anything. And more so when the trial is conducted by before another court. Now there is no point in thinking about the evidence also, because it is already over. I mean, it's a way of looking at it. So as far as lawyer's job is concerned, you did your part so well that you should be satisfied. Yes.
I have nothing to show, so I have to obey your lordship's judgment, my lord. But the scribe of the will, in her cross-examination, he has also...
No, the problem is that scribe, they also got confused. There was no need to bring in Exhibit 5, who scribe. You would have marked that, have a refer to the scribe of the will. Because neither you are relying on the Exhibit 5 in your written statement, nor they are relying on in their plaint on Exhibit 5. At times, actually, the strategy of the lawyer who is conducting the trial depends. It was his choice. But ultimately, if by proving of the will or not proving of the scribe, it leads to nowhere. As far as the dispute is what? whether this Gokul is son of Gokul Gardia is son of Mangulu Gardia or Gokulu Gardia is son of Sriram Ganda.
But in fact,
for that, Gokul was successful for some reason. Because it is so apparent. I don't know how the LA collector could have awarded that amount to somebody other than who has a different name. Whether he is a legal heir of Sriram Ganda, that has not been assessed. His title is different. His voter ID is different.
In fact, Mongol Gadia,
maybe
the land of Mongol Gadia
collector. Maybe the land. Interestingly, Gokul Gardia, has he received compensation that was awarded to Mangulu Gardia?
No, my lord.
Who received that?
That he has not received. Mangulu
Gardia's land has been also acquired in village Kirei.
My lord.
So I didn't ask you. It is not that I have not seen it. Because already there is a lot of time spent. So that would have cleansed the issue. So that I told you that if you start reflecting on annexer A, this exhibit A in juxtaposition to exhibit 4, a lot of problem will come out. Why the land acquisition collector gave you that money? It was only the High Court's order that saved the situation. If the land acquisition collector also acquired Mangulu Gardia's property and awarded compensation, who received it?
I don't know, my lord, but he has not received. Who received it?
That he has not said. That he has not said. Go by what is there on record. Always facts, the points or the evidence, exhibits, they can't change their version. They will remain as it is throughout the litigation. There are very interesting aspects that creates more doubt that you see. I mean, and why you did not produce? Why you did not produce Mangulu Gardia to say that he is not your father? I asked you about the mother. You could have very well produced that I have lost my land, I have received compensation. Gokul is not my son. Gokul is son of Sriram. Your mother could have said, who are the legal heirs of Mangulu? And how you disown your school admission register and voter ID card? These are the other aspects. You wanted to say something else. You wanted to discuss something. Please.
ମୁଁ ଏଇ ଗୋଟେ କହୁଥିଲି ଯୋଉ ମଙ୍ଗଳ ଗାଡିଆର ଯୋଉ ଆକ୍ୱିଜିସନ ହେଇଛି ତାର ଇଏ ପାଇନି ଆଜି ସନ୍ ସେଟା ପାଇନି ସେଟା ଆପଣ ସେଟା କହିସାରିଲେଣି ମୁଁ
କିଏ ପାଇଲା
ଏ ଗୋକୁଲ ଗାଡିଆ ପାଇନି
କିଏ ପାଇଛି
ସେଟା
did that money vanish into thin air? How this land acquisition collector in the same place, same village could not see these persons? How he could find out that he's this Sriram Ganda was died issueless and he's the son of his title is Gardia. He knows there is a village. You said that his land has not been acquired. Your answer is that his land has been acquired. In village Kirei, Mangulu Gardia's land has also been acquired.
Yes, ma'am, acquired.
It has been acquired. Yes, next, Akantu. 38, Mr. You are there, Mr. 38. 38 assigned to?
It's assigned to me, but
yes, you are there. Mr. Sethi for AC for the Ansuman Sethi AC for the appellant. Mr. Suman Sahoo on behalf of MK Mahapatra for the respondent. Learned counsel for the adjournment is sought for adjournment is sought for on behalf of the learned counsel for the respondent.
Same for
on consent list on 2/7/2025. Yes, Your Lord.
Same for item number 39, Your Lordship.
39 same.
Same.
You have been assigned with Achuman, you have been assigned with 39 also.
39 also, Your Lordship.
40.
40, yes.
Lordship, as per noting, the notice was solved, Your Lordship, but has not appeared. No one is appearing for respondents in this matter, Your Lordship.
When it was served, any idea? Have you checked?
Your Lordship, as per noting, it was reflected, Your Lordship.
40, Mrs. D. Sahoo.
Yes, Your Lordship.
D. Sahoo for the appellant. Respondent likhibe. The R1, respondent R1, mane respondent 1, Ansuman Sethi. The office note dated 23/4/25 put up by the registry indicates the following. It is Roman 2 ta lekhi debe. Admission notice you are to return back. Have you served on the extra copy? You have copy.
Copy
No,
was
Your
not,
Lordship,
Your
we haven't.
Lordship.
You have copy memo.
We haven't got the copy.
Nahi.
Lordship, on 24th of March 25, we already solved copy, Your Lordship.
Dekhuntu the Roman 2, Roman 3 lekhile. The learned council, Mr. Sahu submits that they have served copy of the appeal memo on the learned council for the state. Na apna counter re dekhibe. Have filed the copy of the appeal memo in the received counter in the counter designated counter of the office of the Advocate General. The learned request for an extra copy.
Lordship, I will solve. Let's see.
Your Lordship, also there has to be an instruction to be served to the LA, and no letter has been sent for the last instance. So
You sent it.
send a letter again, Your Lordship.
The track consignment put up in the file dated 23/4/25 indicates that the postal article was delivered at Bodmal branch office to the addressee. Through Bodmala to the addressee. Since no one is appearing for the R2, registry shall verify any learned counsel if has entered appearance list on. ଆଣନ୍ତୁ ଆଉ ଗୋଟେ ଦିନକୁ ଯଦି ସେ ଆଉ ଥରେ ନୋଟିସ ନେବେ ବାହାର ନା କେବେ 13/5/2025
Let's see. Let's see, entry model is there.
entry order dated so and so shall continue till the next date.
Grateful, Your Lordship.
पासवर्ड किसी रहेगा कि? Thank you.
Your Lordship.